ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಕೆಎಸ್ಬಿಸಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮ್ಮೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಇಂದಿನ ಮುಖ್ಯ ಅತಿಥಿಗಳಾಗಿ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾದಂತಹ ಶ್ರೀ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಅವರು ಆಗಮಿಸಿದ್ದಾರೆ. ಅವರಿಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಕೆಎಸ್ಬಿಸಿ ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ಹೃತ್ಪೂರ್ವಕವಾದ ಒಂದು ಸ್ವಾಗತವನ್ನು ಬಯಸ್ತಾ ಇದ್ದೇನೆ. ನಮಸ್ಕಾರ ಸರ್. ಇಂದಿನ ವಿಷಯ ನವಯುಗದ ವಕೀಲರಿಗೆ ಜೀವನ ಸೂತ್ರಗಳು, the life skills for the next generation advocate. To speak about today's chief guest, Honorable Mr. Justice Suraj Govindaraj was born on 14th of May 1973 and graduated from the National Law School and enrolled as an advocate on 23rd June 1995. He practiced in the field of civil, commercial litigation, contracts, property law, arbitration, company law, intellectual property rights, constitution matters, debt recovery, environmental law, revenue matters, consumer law, RERA, etc. He appeared before the Honorable Supreme Court of India and almost all high courts in the country, district courts, tribunals, etc. He was appointed as the additional judge of the Karnataka High Court on 23rd of September 2019, and he was made permanent judge on 1st of March 2021. He is a member of Phase 3 Committee Advisory, Implementation and Monitoring Committee, Neutral Citation Committee, and Artificial Intelligence Assisted Translation Committee constituted by the Honorable Chief Justice of India. He is also a member of Computer and Technology Committee of the High Court of Karnataka. He was instrumental in setting up Telegram channel, which is used by most of the lawyers in Karnataka, a revamping of the website of the High Court of Karnataka to give information in one place, publication of various reports in the Telegram channel, which are of assistance to all lawyers and judges, post-integration at the High Court and District Courts, which gives the status of the service by the Postal Department, advocate registration and dashboard to give real-time information to the learned advocate of their cases, etc. He is also a member of several other committees, including the Mediation Committee. He is regularly invited by the National Judicial Academy, Bhopal, on a regular basis to speak to Bhopal as also the regional judicial conferences. He is also invited by various colleges in and outside Bangalore to deliver lectures on various subjects. He has a tremendous interest in sharing knowledge and encouraging lawyers, more particularly the young lawyers. So on behalf of the Karnataka State Bar Council, Karnataka KSBC Law Academy, and the entire legal fraternity of the Karnataka State, I request Sri Suraj Govindaraj, Judge, Karnataka High Court, to take out the session and deliver the lecture. I'll give this screen sharing option, sir. Oh, the house is full. Please do not worry. The session is being recorded and the same will be telecast on Facebook as well as the YouTube. Yes, sir.
It looks like you have scored a century. Good evening, everyone.
Yes, sir. Actually, many are waiting. They're calling me, but I'll telecast later.
Good to see so many of you here. Good evening, everyone. Let me start sharing the screen.
Yes, sir, it's visible.
Yes. Life skills of a next-gen lawyer. When Mr. Basraj called me and asked me to deliver a talk on one of the topics, legal topics, I said, legal topics are fine, but today we are in a cusp of technology. Today we are in a situation where technology is affecting all parts of our lives, more so in terms of the litigators who are practicing before court. Of course, the lawyers who are practicing outside court, they are very much in tune with the technological advancements which are happening, but in court, there is still, people are getting used to it. So I thought, let's speak of what is the life skills that a next generation lawyer would have to possess, more particularly with regard to litigation. Now, life skills, this is the Wikipedia definition of it, life skills are abilities for adaptive and positive behavior that enable humans to deal effectively with the demands and challenges of life. This concept is also termed psychosocial competency. The subject varies greatly depending on social norms and community expectation. But that skills, but skills that function for well-being and aid individuals in developing into active and productive members of their communities are considered as life skills. So just to put communication and interpersonal skills, communication is a key skill for you to argue before the court. Self-awareness and empathy. Empathy is very much required for you to have with the client because you need to understand what trouble or what problem the client is going through. Then only you would probably be able to uh, place his position before the court. It is not sympathy, it is not identification with the client, it's empathizing the situation. Don't get me wrong, it is not identification with the client, it is only empathy aspect to understand the position of the client. Assertiveness and equanimity. You have to be assertive in court, but also to be equanimous. You don't need to shout, scream, or anything. You have to assert. Resilience and coping with emotions and stress. All the lawyers are one of the fields where there's so much of stress that you have to deliver so much that there would be stress. So you need to have resilience and you need to cope with stress. Until now, the life skills for a lawyer were, or the skill set for the lawyers were communication. You need to be excellent communicators in order to effectively communicate with clients, judges, and other legal professionals. Critical thinking, need to be able to analyze complex legal issues and use critical thinking skills to develop strategies for resolving legal disputes. Research and analysis, must be able to research and analyze legal cases, laws, and regulations in order to provide sound legal advice to their clients. Time management, must be able to manage their time effectively in order to meet deadlines and handle multiple cases at the same time. Attention to detail, must be detail oriented. Negotiation and conflict resolution, must be skilled negotiators and be able to resolve dispute between parties. Ethics and professionalism will always be there, must adhere to strict ethical standards and maintain professionalism in all aspects of their work. Adaptability, must be able to adapt to changing legal landscape and be open to new ideas and approaches. Interpersonal skills, must be able to build and maintain strong relationship with clients, colleagues, and other legal professions. Stress management, must be able to manage stress effectively. These are all things which were there till now. I'm not laying much stress on this because most of you know that these are the aspects that you need to be, these are the skill set that is required to be there. Now, what we need to focus on, or what I intend to focus on, is from now what? What are the changes that have been brought about? It is not that the skill set that I refer to are done away with, they are also required. But what is required from now is technological competence. It is not that the older way of doing it is done away with, but that is also part of it. All of you, the next gen lawyers who are now, who have just now passed out or who have been in the profession for 4 to 5 years or who are going to pass out, it is very much required that basic technological competence is required. We are having e-filing, we are going to get paperless court, we have so many other things which are all based on technology. It's not on paper. Paper, you could open the file, you could draft a document. Earlier, we used to use a typewriter. Now we use computers. So basic skill set of computers is also required. Earlier, we used to have secretaries who used to take out dictation and they would type it out. Now, secretaries is also a dying field. So many a time, if you have to get ready the pleadings, you will have to type it out. You will have to get it ready. You will have to align it. This technological competence of using Microsoft Word or Google Documents or LibreOffice would be very much required. Technological competence must have strong technical skills to adapt to the use of legal technology and effectively use it to improve their practice. You use Manupatra, you use SEC, you use so many legal research search engines which are available. Data analytics, must be able to analyze data to make informed decisions, identify trends, and gain insight. This data analysis could be on the basis of research. If whatever research you have done, how is the law grown? Where is the law going? Is an analysis, is a process that there is Article 21 interpretation started from where and where are we now today? If you are practicing in the High Court. Specific performance, where did it start from? Where are we today? If you look at Hindu Succession Act, where did we start from? Where are we today? To give you an example, if we earlier maintenance was not provided for living relationship, but some lawyer came up with this argument, brilliant argument to say that even living in relationship, a person in such a relationship should be entitled to maintenance. So that is a uh, that is what came up through a lawyer, which was accepted by a court. So data analytics to take it to a particular thing. Data is not just what we are dealing with, either as court or as lawyer, is data. Everything is a data point. So analysis of the data to make informed decision, to identify trends, to take it to the next level is also something that a lawyer has to do. Case management, this is going to be a crucial factor because case management systems are going to be implemented. How are you going to handle your case? When is the written statement to be filed? When is the evidence to be filed? When is the cross-examination to be done? When the arguments are to be done? You need to have a proper case diary and a case management system so that you don't forget that this matter is posted for that stage on that particular date. Many a time you come to court and you seek for adjournment when the matter is posted for written statement, record it on your file or the docket, go back, enter the diary and forget about it. Now it won't be that. We need to do a asynchronous. The concept of asynchronous hearing is also coming about. This is another technological innovation which has been the trend in the European Union and the US. So case management is going to be crucial. You need to have strong case management skills to manage large amounts of information, deadlines associated with litigation. We'll have e-discovery probably. E-discovery will have to be done electronically of the email. So all those things would have to be done. Innovation and creativity must be able to think creatively and innovatively to solve complex legal problems and develop new legal solutions. As I said, living in relationship was something that was not thought of earlier, but today it is. Same-sex marriage, that was not thought of earlier, but it is. Transgender reservation was not thought of earlier. There's so many aspects which are in as our constitution is a living constitution. It's a transformative constitution. So innovation and creativity is what brings about life into the constitution, into the law. Law is life. So when that life is the innovation and creativity instilled into law, then the solutions that come about for the litigant and for the society as a whole could be tremendous. Those of you who will be dealing with commercial matters, you also need to have business acumen. You must have strong understanding of the business principles, able to strategically advise the client. You must be able to read a balance sheet, read the accounts to understand what is the situation. If you go before the NCLT, how do you read a balance sheet? If you go before the RERA, how do you see the project costs which have been input into that particular project? Because each project has to be accounted separately. These are all aspects which are now come about, which you need to get aware of. That by reading that balance sheet, you will be able to see whether that company is able to pay its debt or not in an NCLT proceeding, whether it can be restructured or not. If it's a commercial transaction, a share purchase agreement or a share transfer agreement, again, there would be a lot of business requirements, which of course, a non-litigation lawyer would be drafting, but in litigation, you will need to have those skill sets also to be able to understand and thereafter to be able to explain to a judge who is sitting in court. So business acumen would also be very important. Emotional intelligence, must have high emotional intelligence and be able to understand and empathize with clients and colleagues we dealt with earlier. Cultural competence. See, today we are not lawyers who are handling matters only in Bangalore. There are matters which come to you from Delhi, Bombay, Calcutta, maybe outside the country. The clients are from different cultures. They are diverse. They come from diverse backgrounds. It may be that you are in Tumkur, but you are getting a client from Bangalore, which has a different mindset. So culturally competent and be able to work with diverse clients. Collaboration. Much of the references which will come will be from other lawyers from other jurisdictions. So you need to have collaborative effort. You should be able to work with a lawyer from that particular jurisdiction who has referred the matter to you. Flexibility and adaptability. You must be able to adapt to changing circumstances and approach in legal problem solving. You also need to have an entrepreneurial mindset. Must have be willing to take risks to achieve success in their legal practice. You need to work. It is not just work, but you need to put in place some things where you could, with that entrepreneurial mindset, go across and be a go-getter. As it's a lifelong learning experience in especially litigation and for lawyers as a whole. Now, what are the technical skills that you need to put in place or you need to understand for you to be successful or for you to practice in future? We are going towards paperless court. When we go towards paperless court, there won't be any file that you will carry. There won't be a file before the court. Everything will be in the electronic medium. How do we get that into electronic medium? Firstly, there should be a digitization of the existing records, the legacy records, which are already there on the file of the court. Then going forward, whatever comes in can come in only through e-filing. For example, in Karnataka, all government advocates need to do electronic filing. All the government objections, etc., electronically filed. Today, we have, in Karnataka, we have made tax compulsorily to be filed electronically. Going forward, slowly and steadily, most of the rosters, most of the classification will have to be electronically filed. So you must understand the electronic filing. You have to go through the electronic filing page, e-filing page as we call it, to understand how the e-filing has to be done. Probably detailed classes could be held or seminars could be held on e-filing. But for now, if you want some basic understanding, if you are using Telegram channel, you can search for e-committee. When you search for e-committee, there is a channel started by the e-committee which you can subscribe to. There are a lot of material. There are manuals, there are training videos which are available for e-filing. You can watch the e-filing videos, learn how to e-file. These videos are already available. There are manuals which are available. You can download it, you can take a printout if you want, or you can see it electronically and learn how to electronically file. So you must be able to navigate electronic filing systems to file documents with courts and other agencies. Tomorrow, probably the e-filing will come in quasi-judicial bodies, in tribunals. You will have to e-file. Today, we do online application for kata. We do an online application for a mutation. Today, we do an online application for grant of a mining license. Almost everything is going online. Every application that needs to be filed will have to be filed online. So filing of material online will also require processing of the documents. That document should be machine readable. The document scanning is the next thing. Must know how to scan paper documents to create electronic versions of machine readable documents that can be uploaded and filed electronically. So you need to have a scanner. You need to understand, if you have somebody else able to do it for you, well and good. But if you don't have, you will end up doing it. Like when we started, a clerk used to stitch the file. If the clerk was not there, we used to stitch it ourselves. To give you an example, that stitching of a file and now document scanning is more or less the same. We used to put all the papers together. We used to photocopy sometimes when the clerk was not there. We would photocopy, we would put it together, we would stitch it and go and file it. But today it could be document scanning which replaces that entire process. You need to know how to scan paper documents, create electronic version with PDF-A, which is machine readable, so that you can upload it. Document management software. You must be able to use the document management software to organize, share and review digital documents. There is versioning of documents so that you don't upload a document which is an older version. Imagine if you upload an older draft version of a pleading, what could happen? So you should know, you should introduce document management so that you know which is the latest version. It could be just by a nomenclature of the file. It could be a proper document management system. You should be able to upload the because uploading is only selecting a file. Printing and signing is a different thing. You'll read it. But when you're uploading, you don't know what is inside the file. You are selecting a file name. So the versioning of the documents to be able to know which is the latest document would also be a very important feature for you to understand. Optical character recognition, OCR, you convert scanned documents into searchable text. There may be documents which are available on your machine, which a client may send to you, which is not machine readable or searchable. So you'll need to use OCR language, OCR software to convert it into machine readable. Electronic signatures. Today, the physical signatures are accepted, but going forward, you will have only electronic signature or digital signature. Once you electronically sign it, that is done. There may not even be need of a Section 65B certificate. You electronically sign it, it is accepted to be an authenticated document. The signatures are only for authentication. Today, we have notaries who are notarizing a particular document. In Europe and US, you have e-notaries who have come about. So you can get a document which can be e-notarized. There's also a system which has come in as recording a oath. So when you're filing something, a video recording of the deponent could be uploaded, where the deponent in his video of the deponent could be recorded, where in his voice he says that whatever he has uploaded or whatever is submitting is true to the best of knowledge, information, and belief. So that is a manner of accepting the veracity of a document. Notary, what is he doing? He's only identifying the identity of a person and the signature of the person who is who has signed something, which is filed before the court. So electronic signature, e-notary, recording of a voice file to verify the authenticity of a document could be something which has already come in, which will probably come into India also. Encryption and digital security. You have a lot of data which will come about. You'll have a lot of documents which will be uploaded onto the e-filing. You'll be downloading a lot of documents. So digital security is very important. You should have antiviruses. You should have Windows Defender softwares. You should have ransomware softwares which are installed, which will protect your computer from invasion, phishing, etc., and also protect the client information. So these kind of trends of digital security will also be required if you are storing it on your own machine. Of course, this is not required for everybody. If you are not using your own machine and you are electronically filing using eSeva Kendra, you can go and file it in the eSeva Kendra, which can be uploaded where all these things may not be required. But at some point of time, probably you will have your own machines that you will use where these things could be required. E-discovery. You must be able to use e-discovery software to manage electronic discovery in litigation. Email correspondence is what is available now. Earlier, we used to have printed documents, printed correspondence, signature on it, RPAD cards, RPAD receipts, and RPAD cards accompanying it. Going forward, most of these communication may be electronic. So if there are a bundle of emails running thousands of them, you'll have to be able to search what you want to look for or what you want using e-discovery software. That may be in a few cases, but that is something that you'll have to look at. Video conferencing software, you must be proficient in using video conferencing to conduct virtual meeting, depositions, and court. You may conduct your meeting with the clients using video conferencing. You will appear before the court using video conferencing. And when you are appearing before the court using video conferencing, some of the things that we have observed, the name of a person is not input. It will be Apple 12, Oppo 12, Samsung M150. Please make it clear. Please learn how you could have your own name in the login, so that name is reflected in the virtual hearing before the court, so that the judge can address you by your name instead of Oppo 12, because it is very difficult. You see, and it's not proper to call somebody by Oppo 12. It's better to call somebody by your name. And many a time, profile photographs. This is something which is pretty sensitive, but sometimes some profile photographs which should not be there are there and available for everybody to see. So be very careful on profile photographs. Thirdly, be very careful on lighting. You should be able to be seen. Many times people see with a light in the background. Light has to be on you, not behind you. If it is behind you, you can't be seen because that light hits the camera. So light has to be in front of you. Light has to be on your face so that you are seen properly. Basuraj corrected himself now on that. So these are things, these are small things. Profile pictures, names, lighting, which go a long way in your presenting the case properly. Electronic presentation software. Now, there could be a situation where you are appearing from one place and the court is at another place. We have document visualizers which are now being installed. So you can put up a document on that document visualizer. The document could be presented to the court. Well, final arguments. For example, you want exhibit P30. P30 can be put on it. It could be available on the screen. The judge and you on the other side can watch that. It's an electronic presentation software. So the instrument uses a document visualizer. Collaboration software. You will have a same document being worked upon by different people. So you need to be able to use collaboration software. Going forward, you may have cloud computing. Everybody, every lawyer in every nook and corner of the country is using a computer. Everybody is using MS Office or LibreOffice or Google Docs. Google Docs, if you're using, the collaborative efficiency of it, 0365. So cloud computing, everything would be on cloud. You will also probably be able to use virtual private networks to secure the connections so that you could log in without a problem, without any interference or without the risk of anybody interfering with the connection. We may also have document redaction software. Especially in matrimonial matters, there could be issues about defamation. If there are some documents which are produced in court which are defamatory in nature, there could be going forward defamation actions initiated. So redaction is important so that some of the sensitive information is not presented. Apart from that, in 376 matters, POXO matters, there are a lot of things which need to be redacted. You can't have the name of the victim be shown in the pleadings also probably in future, because that comes, if you look at Puttaswamy's judgment, Justice Puttaswamy's judgment, it is a privacy issue. So there's a committee looking into the privacy issues. Probably guidelines will come soon. Those guidelines will also have to be complied with. Most of you have smartphones. You should be able to use smartphones or tablets to access the court files also. Your phone could be your office. Your tablet could be your office. Your laptop could be your office. The entire office could be carried by you in your hand. You don't need everything. We have now the repository of judgments. With the repository of judgments accompanied by neutral citations, you can access all judgments. You can access India Code for the legislations. You will probably have something for the local, the state enactments and state regulations also. So everything could be on your phone. There should not be a situation where I don't have it is not an answer. I have to go look at go back to my office and look at particular book is not an answer. You will probably be able to access everything. You will be more efficient if you are able to do that. Now, these being the aspects that you need to look at and you need to train yourself, these are all small droplets of water. And as they say, that is how this screen is all structured with a lot of water droplets. All these water droplets, if you can assimilate, it becomes a mighty ocean. You will become a stronger personality. These are the skill sets that will help you achieve what you want to achieve in a better way. These are the broad parameters that I am putting across. I wanted to leave a little time for interaction also, so that any questions that come across, we could answer on a interactive mode.
ಸರ್, ಕನ್ನಡದಲ್ಲಿ ಸ್ವಲ್ಪ ಹೇಳಿ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ. ಸೊ
ಕನ್ನಡದಲ್ಲ?
ನಾವು ವಾಪಸ್ ಹೋಗಿ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ. ಸೊ ಕ್ವಿಕ್ ಆಗಿ ಮಾಡ್ಬೋದು. ಯಾಕಂದ್ರೆ ಪೋಸ್ಟರ್ ಕನ್ನಡದಲ್ಲೂ ಇತ್ತಲ್ಲ, ನವಯುಗದ ವಕೀಲರಿಗೆ ಜೀವನ ಸೂತ್ರಗಳು ಅಂತ. ಅವರು ಸ್ವಲ್ಪ ಎಕ್ಸೈಟ್ ಆಗ್ತಾರೆ.
ಪ್ರೆಸೆಂಟೇಷನ್ ಸ್ವಲ್ಪ ಕನ್ನಡದಲ್ಲಿ ಮಾಡಕ್ಕೆ ಕನ್ನಡದಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತೀನಿ
ಸರ್.
ನಮ್ಮ ವೃತ್ತಿಯಲ್ಲಿ ನಮ್ಗೆ ಸಕ್ಸಸ್ ಆಗ್ಬೇಕು ಅನ್ನೋ ಏನು ಬೇಕು, ನಮ್ಮ ಲೈಫಲ್ಲಿ ಸಕ್ಸಸ್ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಏನ್ ಬೇಕು ಅದನ್ನ ಲೈಫ್ ಸ್ಕಿಲ್ಸ್ ಅಂತಾರೆ. ಲೈಫ್ ಸ್ಕಿಲ್ ಅಂದ್ರೆ ನಮ್ಗೆ ಬೇಸಿಕ್ ಏನಿದೆಯೋ ನಮ್ಗೆ ಇದು ಗೊತ್ತಿದ್ರೆ ನಮ್ ಪಾಸಿಬಿಲಿಟಿ ಆಫ್ ಸಕ್ಸಸ್ ಆಗೋದು ಒಳ್ಳೇದು ಅಂತ. ಅದ್ರ ಪ್ರಕಾರನೇ ಇವಾಗ ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ಅಂದ್ರೆ ಒಂದು ಡಿಸಿಷನ್ ಮಾಡೋದು, ಆ ಪ್ರಾಬ್ಲಮ್ನ ಹೆಂಗೆ ಸಾಲ್ವ್ ಮಾಡೋದು, ಹೆಂಗೆ ಯೋಚನೆ ಮಾಡೋದು, ಅದನ್ನ ಲ್ಯಾಟ್ರಲ್ ಥಿಂಕಿಂಗ್ ಅಂತಾರೆ. ಸ್ಟ್ರೇಟ್ ಥಿಂಕಿಂಗ್ ಇರ್ಬೋದು. ಕ್ರಿಯೇಟಿವ್ ಅಂದ್ರೆ ನಮ್ಮ ಲಾ ಅಲ್ಲಿ 2+2 = 4 ಅಲ್ಲ, ಅದು ಮ್ಯಾಥ್ಸ್. ಲಾ ಅಲ್ಲಿ 2+2 could be 22, could be 5, could be 7. ಅದರದ್ದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಫ್ ಹೌ ಇಟ್ ವಿ ಲುಕ್ ಅಟ್ ಇಟ್. ಏನು ನಮ್ಮ ಮುಂದೆ ಯಾವ ಫ್ಯಾಕ್ಟ್ ಸಿಚುವೇಶನ್ ಬರುತ್ತೋ, ಯಾವ್ದು ಲಾ ಇರುತ್ತೋ, ಅದು ಆ ಲಾ ಆ ಫ್ಯಾಕ್ಟ್ ಹೆಂಗ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಫ್ಯಾಕ್ಟ್ಸ್ ನೀವೇನು ಚೇಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಲಾ ಏನು ಚೇಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಇವು ಎರಡು ಮಧ್ಯದಲ್ಲಿ ಹೆಂಗೆ ಅದನ್ನ ಇಂಟರ್ಪ್ರೆಟ್ ಮಾಡಿ, ಅದನ್ನ ಎರಡಕ್ಕೂ ಹೋಲಿಕೆ ಮಾಡಿ ನೀವು ಹೆಂಗೆ ಕೋರ್ಟ್ ಮುಂದೆ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರೋ, ಅದು ನಿಮ್ಮ ಕ್ರಿಯೇಟಿವ್ ಥಿಂಕಿಂಗ್, ಅದು ನಿಮ್ಮ ಯೋಚನೆ ಮಾಡೋ ಇದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಕಮ್ಯುನಿಕೇಶನ್, ನಾವು ಹೆಂಗೆ ಮಾತಾಡ್ತೀವಿ ಕೋರ್ಟಲ್ಲಿ, ಏನು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ, ಹೆಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ, ನಮ್ಮ ಅದರ್ ಸೈಡ್ ಜೊತೆ ಹೆಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ, ನಮ್ಮ ಕ್ಲೈಂಟ್ ಜೊತೆ ಹೆಂಗೆ ಮಾತಾಡ್ತೀವಿ, ಏನು ನಾವು ಕನ್ವೆ ಮಾಡೋಕ್ಕೆ ಕರೆಕ್ಟಾಗಿ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರಿಗೂ ಅರ್ಥ ಆಗುತ್ತೆ. ನಮ್ಮ ಮಾತಾಡೋದ್ರಲ್ಲೇ ನಮ್ಗೆ ಕನ್ಫ್ಯೂಷನ್ ಇದ್ಬಿಟ್ಟು ನಾವು ಸರಿಯಾಗಿ ತಿಳಿಸ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯಾರಿಗೂ ಅರ್ಥ ಆಗಲ್ಲ. ಅರ್ಥ ಆಗಂಗೆ ಮಾಡೋದು ಕಮ್ಯುನಿಕೇಶನ್ ಅಂಡ್ ಇಂಟರ್ಪರ್ಸನಲ್ ಸ್ಕಿಲ್. ಸೊ ಅವ್ರ ಜೊತೆ ಹೆಂಗೆ ಹೊಳ್ಕೊಂಡಿರ್ಬೋದು, ಅದು ಇಂಟರ್ಪರ್ಸನಲ್ ಸ್ಕಿಲ್. ಎಂಪತಿ ಅಂದ್ರೆ ನಿಮ್ಮ ನಾವು ಒಂದು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂದ್ರೆ, ಯಾರೂ ಕಕ್ಷಿದಾರರು ಲಾಯರ್ ಹತ್ರ ಬರಕ್ ಇಷ್ಟಪಡಲ್ಲ, ಯಾರು ಕೋರ್ಟ್ಗೆ ಬರಕ್ ಇಷ್ಟಪಡಲ್ಲ. ಏನೋ ಒಂದು ಸಿಚುವೇಶನ್ ಆಗಿದೆ, ಆ ಲಿಟಿಗೆಂಟು, ಆ ಕಕ್ಷಿದಾರ ಇಸ್ ಫೋರ್ಸ್ಡ್ ಟು ಕಮ್ ಟು ಕೋರ್ಟ್ಗೆ ಬರೋಂಥ ಪರಿಸ್ಥಿತಿ ಬರುತ್ತೆ. ಆ ಪರಿಸ್ಥಿತಿ ಬಂದವಾಗ ಕೋರ್ಟ್ಗೆ ಬರ್ತಾನೆ. ಬಂದವಾಗ ಆ ಕೇಸ್ ಅವನ್ಗೆ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ನಿಮಗೆ ಚಿಕ್ಕದು ಅನ್ಸ್ಬೋದು, ದೊಡ್ಡದು ಅನ್ಸ್ಬೋದು, ಬಟ್ ನಿಮ್ಮ ಕಕ್ಷಿದಾರನ್ಗೆ ಅದೇ ಕೇಸು ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ಆವಾಗ ನೀವು ಅವ್ರ ಜೊತೆ ಅವ್ರ ಸಿಚುವೇಶನ್ ಏನಿದೆ ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ನಿಮ್ಗೆ ಏನಪ್ಪ ಇದು ಚಿಕ್ಕದು ಅಂತ ಒಂದು ಇದು ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ, ನಾವು ಒಬ್ಬರು ಡಾಕ್ಟರ್ ಕೇಳ್ತಾ ಇದ್ದೆ, ನ್ಯೂರೋ ಸರ್ಜನ್. ಡಾಕ್ಟ್ರೆ, ಹೆಂಗೆ ಇದು ಈ ಆಪರೇಷನ್ ಸ್ವಲ್ಪ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಅಲ್ವಾ ಅಂತ. ಡಾಕ್ಟರ್ ನಂಗೆ ಸಿಂಪಲ್ ಆಗಿ ಹೇಳಿದ್ರು, ನನಗೇನಿಲ್ಲ, ನಾನು ದಿನ ಒಂದು 5-6 ಮಾಡ್ತೀನಿ ಇಂಥದ್ದು ಆಪರೇಷನ್ನು, ನಿಮಗೆ ಸ್ವಲ್ಪ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಅಂತ ಹೇಳಿದ್ರು. ನಮ್ಮ ಲಾಯರ್ ವೃತ್ತಿಯಲ್ಲಿ ನೋಡಿದ್ರೆ ನಮ್ಗೇನಿಲ್ಲ, ಒಂದು 6 Rule 17 ಅಪ್ಲಿಕೇಶನು, 1 Rule 10, 39 1 and 2 ಡಿಕ್ಲರೇಷನ್ ಸೂಟು, ಏನು ಪಾರ್ಟಿಷನ್, ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ನಮ್ಗೆ ರೆಗ್ಯುಲರ್ ಆಗಿ ಮಾಡ್ತಾನೆ ಇರ್ತೀವಿ. ಬಟ್ ಆ ಕಕ್ಷಿದಾರನ್ಗೆ ಆ ಇಂಜಂಕ್ಷನ್ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನಾಗ್ಬೋದು, ಇಲ್ಲ ಇಂಜಂಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಸಿಕ್ಕಿದ್ರೆ ಏನಾಗ್ಬೋದು, ಆ ಎಂಪತಿ ಬೇಕು. ಆ ಅರ್ಥ ಮಾಡಿಕೊಂಡು ನೀವು ಆವಾಗ ವಿ ಆರ್ ದ ಮೌತ್ ಪೀಸ್ ಫಾರ್ ದ ಕ್ಲೈಂಟ್ ಟು ಸಮ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಸ್ ಲಾಯರ್ಸ್. ಸೊ ಯು ನೀಡ್ ಟು ಹ್ಯಾವ್ ದಟ್ ಎಂಪತಿ. ಅವ್ರ ಸಿಚುವೇಶನ್ನ ನಾವು ಅರ್ಥ ಮಾಡಿಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ಕೋರ್ಟಲ್ಲಿ ಅಸರ್ಟಿವ್ ಆಗಿರಬೇಕು. ಅಂದ್ರೆ ನೀವು ಗತ್ತಲ್ಲಿ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೋದು, ಬಟ್ ಅದು ಮಾಡೋವಾಗ ಜೋರಾಗಿ ಕಿರ್ಚಾಡೋದು ಎಲ್ಲ ಅಸರ್ಟಿವ್ ಅಲ್ಲ. ಕಿರ್ಚಾಡಿದ್ರೆ ಅಸರ್ಟಿವ್ ಅಂತಲ್ಲ, ಕರೆಕ್ಟಾಗಿ ನೀಟಾಗಿ ಇದು ಈ ಪಾಯಿಂಟ್ಗೆ ಹಿಂಗೆ ಅಂತ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರೆ ಸಾಕು. ನೀವು ನಿಮ್ಮ ಇದರಲ್ಲಿ ಇರಬೇಕು. ನೀವು ಅದು ಒನ್ ಆಫ್ ದಿ ಲೈಫ್ ಸ್ಕಿಲ್ಸ್ ಅಂತ. ಸ್ಟ್ರೆಸ್ ಇರುತ್ತೆ, ಸ್ಟ್ರೆಸ್ನ ಹೆಂಗೆ ಮ್ಯಾನೇಜ್ ಮಾಡೋದು. ಸ್ಟ್ರೆಸ್ನ ನಾವು ಇಷ್ಟೊಂದು ಜಾಸ್ತಿ ಕೆಲಸ ಇದೆ ಅಂತ ಇದ್ರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಸ್ಟ್ರೆಸ್ ಆಗ್ತಾ ಹೋಗುತ್ತೆ. ನೀವು ಮಾಡ್ತಾ ಹೋದ್ರೆ ಸ್ಟ್ರೆಸ್ ಏನಿರಲ್ಲ, ಅದನ್ನ ಕೋಪ್ ಮಾಡಬೇಕು. ನಿಮ್ಮ ರೆಸಿಲಿಯನ್ಸ್ ಇರಬೇಕು. ಇದು ಹೆಂಗೆ ಒಂದು ಕೇಸ್ ಗೆಲ್ಬಹುದು, ಒಂದು ಕೇಸ್ ಸೋಲ್ಬಹುದು, ನಡೀತಾ ಇರತ್ತೆ. ಇದು ಎಲ್ಲ ಕೇಸು ನೀವು ಗೆಲ್ಲಕ್ಕಾಗಲ್ಲ, ಎಲ್ಲ ಕೇಸು ನೀವು ಸೋಲಲ್ಲ. ಸೊ ಗೆಲ್ಲಿಲ್ಲ ಅಂತ ನೀವು ಬೇಜಾರು ಪಡ್ಕೊಂಡು ಸ್ಟ್ರೆಸ್ ಆಗೋದಲ್ಲ. ಇವತ್ತಾಗ್ಲಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಇದು ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆ. ನಿಮ್ ಕೇಸ್ ಚೆನ್ನಾಗಿಲ್ಲದೆ ಇರಬಹುದು, ನೀವು ಯು ಹ್ಯಾವ್ ಟು ಆಲ್ಸೋ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಕೇಸ್ ಹೆಂಗಿತ್ತು ಅಂತ. ಸೊ ಸ್ಟ್ರೆಸ್ ಆಗೋದು ಬೇಡ. ಇದುವರೆಗೂ ಏನು ನಮಗೆ ಲಾಯರ್ಗೆ ಏನು ಅಂದರೆ ಕಮ್ಯುನಿಕೇಷನ್, ನಾವು ಹೆಂಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ ಇನ್ನೊಬ್ಬರ ಜೊತೆ, ನಮ್ಮ ಥಿಂಕಿಂಗ್ ಹೆಂಗಿತ್ತು, ನಾವು ರಿಸರ್ಚ್ ಹೆಂಗೆ ಮಾಡ್ತಾ ಇದ್ವಿ, ಟೈಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಹೆಂಗೆ ಮಾಡಿದ್ವಿ, ಇವೆಲ್ಲ ಸ್ಕಿಲ್ಸ್ ವಿಚ್ ಆರ್ ಇಂಪಾರ್ಟೆಂಟ್. ಅಂದರೆ ಇವಾಗಲೂ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ನೀವು ಟೈಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಎಲ್ಲರಿಗೂ ಇರೋದು 24 ಗಂಟೆನೇ, ಯಾರಿಗೂ 24 ಗಂಟೆಗಿಂತ ಜಾಸ್ತಿ ಏನಿಲ್ಲ. ನೀವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇರ್ಬೋದು, ಇವಾಗ ಫ್ರೆಶ್ ಎಂಟ್ರೆಂಟ್ ಇರ್ಬೋದು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಬೋದು, ಯಾರಿದ್ರೇನು ಎಲ್ಲರಿಗೂ 24 ಗಂಟೆನೇ ಇರೋದು. ಆ 24 ಗಂಟೆ ಹೆಂಗ್ ಯೂಸ್ ಮಾಡ್ತೀರಾ ಅದು ಟೈಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್. ನೀವು ಅಟೆನ್ಷನ್ ಟು ಡೀಟೇಲ್ ಇರ್ಬೇಕು. ನೀವು ಇಗ್ನೋರ್ ಮಾಡಂಗಿಲ್ಲ, ಶಾರ್ಟ್ ಕಟ್ ಹೊಡಿಯಂಗಿಲ್ಲ. ಇದನ್ನ ನಾನು ಇಗ್ನೋರ್ ಮಾಡಿ ಇದೆಲ್ಲ ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಅಂದ್ರೆ ಎಲ್ಲ ನೀವು ಯೋಚನೆ ಮಾಡಬೇಕಾಗತ್ತೆ. ಎಷ್ಟೋ ಮ್ಯಾಟರ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ. ಸೊ ಅದು ಸೆಟಲ್ಮೆಂಟ್ಗೆ ನೀವು ಎನ್ಕರೇಜ್ ಮಾಡಬೇಕು. ನಿಮ್ಮ ಎಥಿಕ್ಸ್ ಅಂಡ್ ಪ್ರೊಫೆಷನಲಿಸಮ್ ಯಾವಾಗ್ಲೂ ನೀವು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ದು. ನೀವು ಅಡ್ಯಾಪ್ಟ್ ಆಗಬೇಕಾಗತ್ತೆ. ಏನೇನು ಚೇಂಜಸ್ ಆಗ್ತಾ ಇರತ್ತೋ ಅದನ್ನು ಅಡ್ಯಾಪ್ಟ್ ಆಗಬೇಕು. ಇಂಟರ್ಪರ್ಸನಲ್ ಸ್ಕಿಲ್, ನಿಮ್ಮ ಸ್ಕಿಲ್ ವಿತ್ ಕ್ಲೈಂಟ್ಸ್ ಇರ್ಬೋದು, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇರ್ಬೋದು, ಕೋರ್ಟ್ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಇರ್ಬೋದು, ಕೋರ್ಟ್ ಪ್ಯೂನ್ ಇರ್ಬೋದು, ಜಡ್ಜ್ ಇರ್ಬೋದು, ಎಲ್ಲರ ಜೊತೆನೂ ಹೆಂಗೆ ಬಿಹೇವ್ ಮಾಡ್ತೀರಾ, ಆ ಇಂಟರ್ಪರ್ಸನಲ್ ಸ್ಕಿಲ್. ಅವಾಗ ನೀವು ಅಲ್ಲಿ ಹೋಗಿದ್ದೆ, ನಿಮ್ಮ ಏನು ಕೆಲಸ ಇರತ್ತೋ, ಕಾಪಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇರ್ಬೋದು ಏನು ಅಂತ, ಅದು ನಿಮ್ಮ ಸ್ಕಿಲ್ಸ್ ಮೇಲೆ ಆಗತ್ತೆ. ಹೆಂಗೆ ನೀವು ಎಲ್ಲರಿಗೂ ಮಾತಾಡ್ತೀರಾ, ಹೆಂಗೆ ಮರ್ಯಾದೆ ಕೊಡ್ತೀರಾ, ಹೆಂಗೆ ನೋಡ್ಕೊಳ್ತೀರಾ. ನೀವು ಹೆಂಗೆ ನೋಡ್ಕೊಳ್ತೀರೋ ಅವರು ನಿಮ್ಮನ್ನು ನೋಡ್ಕೊಳ್ತಾರೆ. ನೀವು ಅವ್ರು ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡಿಲ್ಲ ಅಂದರೆ ಅವರು ಸರಿಯಾಗಿ ನೋಡ್ಕೊಳಲ್ಲ. ಸೊ ಅದು ಇಂಟರ್ಪರ್ಸನಲ್ ಸ್ಕಿಲ್ಸ್ ಆರ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಸ್ಟ್ರೆಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಆಗಲೇ ಹೇಳಿದೆ. ಇದುವರೆಗೂ ಇದ್ದಿದ್ದು. ಇವಾಗ ಮುಂದೆ ಹೋಗೋಂಥದ್ದು ಏನು ಅಂದರೆ, ಇವಾಗ ನಾವು ಪೇಪರ್ಲೆಸ್ ಕೋರ್ಟ್ ಕಡೆ ಹೋಗ್ತಾ ಇದ್ದೀವಿ. ಟೆಕ್ನಾಲಜಿ ಯೂಸ್ ಆಗ್ತಾ ಇದೆ ಕೋರ್ಟಲ್ಲಿ. ಟೆಕ್ನಾಲಜಿಕಲ್ ಕಾಂಪಿಟೆನ್ಸ್ ಬೇಕಾಗಿ ನೀವು ಏನು ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರೋ, ಕನ್ನಡದಲ್ಲೇ ಟೈಪ್ ಮಾಡ್ತಾ ಇರ್ಬೋದು, ಇಂಗ್ಲೀಷಲ್ಲಿ ಟೈಪ್ ಮಾಡ್ತಾ ಇರ್ಬೋದು. ನೀವು ಕಂಪ್ಯೂಟರ್ ಅಂತೂ ಜನರಲಿ ಎಲ್ಲರೂ ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಇವಾಗ ಪ್ರಿಂಟರ್ ಎಲ್ಲರೂ ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಅದು ಆಫೀಸ್ 365 ಅಂತಿದೆ, MS ಆಫೀಸ್ ಅಂತಿದೆ, ಲಿಬ್ರೆ ಆಫೀಸ್ ಅಂತಿದೆ, ಗೂಗಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತಿದೆ. ಅದನ್ನು ಯೂಸ್ ಮಾಡಿ ಹೆಂಗೆ ನಿಮ್ಮ ಟೆಕ್ನಾಲಜಿಕಲ್ ಕಾಂಪಿಟೆನ್ಸ್ನ ಬಿಲ್ಡ್ ಮಾಡ್ತೀರಾ, ಹೆಂಗೆ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತೀರಾ. ಎಲ್ಲ ಟೆಕ್ನಾಲಜಿ, ನೀವೇನು ಟೆಕ್ನಾಲಜಿ ಡೆವಲಪ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಇರೋ ಟೆಕ್ನಾಲಜಿನ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಅನ್ನು ಯೂಸ್ ಮಾಡೋದು ಹೆಂಗೆ ಕಲ್ತ್ಕೊಳ್ತೀರಾ ಅಂತ ಇರೋದು. ಎಲ್ಲ ನಮ್ಮಲ್ಲಿರೋದು ಡೇಟಾ ಅನಾಲಿಟಿಕ್ಸ್. ಏನು ಡೇಟಾ ಇದೆ ಅದನ್ನು ಅನಲೈಸ್ ಮಾಡಿ ಅದನ್ನು ಹೆಂಗೆ ಯೂಸ್ ಮಾಡ್ತೀರಾ ಅಂತಲೂ ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು. ಕೇಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇವಾಗ ಭಾಳ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. ಕೇಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಂದರೆ ಇವು ಯಾವಾಗಲೂ ನಾವು ಏನು ಮಾಡ್ತಾ ಇದ್ವಿ, ನಾನು ಮೊನ್ನೆವರೆಗೂ ಲಾಯರೇ ಇದ್ದೆ. ಹೋಗೋದು, ನಾನು ನನ್ನ ಜೂನಿಯರ್ ಹೋಗ್ತಾರೆ ಕೋರ್ಟ್ಗೆ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಗಿದೆ, ಸಾಹೇಬರ್ ಕೇಳೋದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾಗಿದೆ, ಇನ್ನೂ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಡಿ ಆಗಿಲ್ಲ ಅಂತ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗೋದು, ಬರ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ವಿ ಡಾಕೆಟಲ್ಲಿ, ಕೋರ್ಟ್ ಡೈರಿಯಲ್ಲಿ ಬರೀತಾ ಇದ್ವಿ. ಅದಾದಮೇಲೆ ಮರ್ತು ಹೋಗ್ತಾ ಇದ್ವಿ. ಅದು 3 ತಿಂಗಳ ಹಿಂದೆ ಆಯಿತು, ನಾಳೆ ಬಂತು ಮತ್ತೆ ಇನ್ನೊಂದ್ಸತಿ, ಇವತ್ತು ರಾತ್ರಿ ನಾಳೆ ಬರ್ತಾ ಇದೆ, ಏನು ನಾನು ಮಾಡಿಲ್ಲ ಅಂತ. ಸೊ ಆವಾಗ ಕೇಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟು ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. ನೀವು ನೋಡಿಕೊಂಡು, ನೀವು ಡೇಟ್ಗಳು ಬರ್ಕೊಂಡು, ಈ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತಲ್ಲ, ಅದಕ್ಕಿಂತ ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವಾಗ ಶುರು ಮಾಡ್ತೀರಾ, ಯಾವಾಗ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತೀರಾ, ಎವಿಡೆನ್ಸ್ ಇರ್ಬೋದು, ಯಾವಾಗ ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ಕರಿತೀರಾ, ಯಾವಾಗ ಅಫಿಡವಿಟ್ ರೆಡಿ ಮಾಡ್ತೀರಾ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಾಗತ್ತೆ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಬೇಕಾಗತ್ತೆ. ಕೇಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟಲ್ಲಿ ಇದೆಲ್ಲ ಬರುತ್ತೆ. ಇದೆಲ್ಲ ನಾವು ಮಾಡಬೇಕಾಗಿರೋದು ಆ ಡೇಟ್ಗಿಂತ ಮುಂಚೆ ಮಾಡಬೇಕಾಗಿಂಥದ್ದೆಲ್ಲ ಕೇಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್. ಆ ಕೇಸ್ದು ನೀವು ನಿಮ್ಮ ಮುಂದೆ ಇವಾಗ ಕಾನೂನಲ್ಲಿ ಭಾಳ ಚೇಂಜ್ ಆಗ್ತಾ ಇದೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ನಮ್ಮ ಅರ್ಲಿಯರ್ ಇದು ಆಫ್ ಸೋ ಕಾಲ್ಡ್ ಟ್ರೆಡಿಷನಲ್ ಲಿಟಿಗೇಷನ್ ಅಂತ ಏನು ಹೇಳ್ತಾ ಇದ್ವಿ ನಾವು, ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸು, ಪಾರ್ಟಿಷನು ಎಲ್ಲ, ಅಲ್ಲೂ ಭಾಳ ಚೇಂಜ್ ಆಗ್ತಾ ಇದೆ. ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಚ್ ಆರ್ ಟ್ರೆಡಿಷನಲ್, ಅಲ್ಲೂ ಭಾಳ ಚೇಂಜ್ ಆಗ್ತದೆ. ಇನೋವೇಷನ್, ಕ್ರಿಯೇಟಿವಿಟಿ ಭಾಳ ಬರ್ತಾ ಇದೆ. ಕ್ರಿಯೇಟಿವಿಟಿ ಅಂದರೆ ಇವಾಗ DV ಆ್ಯಕ್ಟಲ್ಲಿ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಆಫ್ ಎ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಹೋಮ್, ಎಂಟೈಟಲ್ಮೆಂಟ್ ಆಫ್ ಶೆಲ್ಟರ್, ಮೇಂಟೆನೆನ್ಸ್ ಫಾರ್ ಲಿವಿಂಗ್ ಇನ್ ರಿಲೇಷನ್ಶಿಪ್, ಇವೆಲ್ಲ ಇನೋವೇಷನ್ ಆ್ಯಂಡ್ ಕ್ರಿಯೇಟಿವಿಟಿ ಎಲ್ಲ ಯಾರೋ ಒಬ್ಬರು ಲಾಯರ್ ಹೇಳಿದ್ರಿಂದಾನೇ ಇದು ಮುಂದೆ ಹೋಗಿದ್ದು. ಯಾರೋ ಒಬ್ರು ಯೋಚನೆ ಮಾಡಿದ್ರು. ಯಾರು ಯೋಚನೆ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಅದು ಪೆಟಿಷನು ಫೈಲ್ ಆಗ್ತಾ ಇಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟು ಆಗ್ತಾ ಇಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟು ಮಾಡ್ತಾ ಇಲ್ಲ. ಇದು ಇನೋವೇಷನ್ ಆ್ಯಂಡ್ ಕ್ರಿಯೇಟಿವಿಟಿ ಬರುತ್ತೆ. ಇನ್ನ ಮುಂದೆ ಹೋಗ್ತಾ ಬಹಳ ಲಿಟಿಗೇಷನ್ಸ್, ಬಿಸ್ನೆಸ್ ಓರಿಯೆಂಟೆಡ್ ಲಿಟಿಗೇಷನ್ ಇರ್ಬೋದು, ಕಮರ್ಷಿಯಲ್ ಲಿಟಿಗೇಷನ್ ಇರ್ಬೋದು, ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಎಲ್ಲ ಕಡೆ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗ್ತಾ ಇದೆ. ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಕಮರ್ಷಿಯಲ್ ಲಿಟಿಗೇಷನ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ನೀವು ಸ್ವಲ್ಪ ಆಸ್ ಎ ಲಾಯರ್, ಬರೀ ಲಾ ಅಲ್ಲ, ಬಿಸ್ನೆಸ್ ಓರಿಯೆಂಟೆಡ್ ಅಪ್ರೋಚು ಇರಬೇಕಾಗತ್ತೆ. ಅಂಡ್ ಬೇಸಿಕ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ಬಿಸ್ನೆಸ್ ಏನಿರುತ್ತೆ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಬ್ಯಾಲೆನ್ಸ್ ಶೀಟ್ ಓದೋಂಥ ಪರಿಸ್ಥಿತಿ ಬರ್ಬೋದು. ಇಲ್ಲ ಯಾರಾದ್ರೂ ನಿಮ್ಗೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ ಇದು ಬ್ಯಾಲೆನ್ಸ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಿಂಗೆ ಅಂತ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬಹುದು. ಹಲವಾರು ಮೆಥಾಲಜಿ ಇದಾವೆ ಹಿಂಗೆ ಮಾಡ್ಬೋದು ಅಂತ. ಯಾರಾದ್ರೂ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೋದು, ನೀವೇ ಖುದ್ದಾಗಿ ಮಾಡ್ಬೋದು. ನೀವು BCom LLB ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ಬೋದು, BA LLB ಮಾಡಿದ್ರೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರ್ಬೋದು. ಸೊ ಬ್ಯಾಲೆನ್ಸ್ ಶೀಟ್ ಓದೋದು, ಶೇರ್ ಪರ್ಚೇಸ್ ಅಗ್ರಿಮೆಂಟು, ಶೇರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಗ್ರಿಮೆಂಟು, NCLT ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ನೀವು ಎಲ್ಲಿ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಮ್ಯಾಟರ್ಸು, ಇಂಜಿನಿಯರಿಂಗ್ ಅಂಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಇರ್ಬೋದು, ಬರೀ ರಿಕವರಿ ಅಲ್ಲ, ನೀವು ಯಾವ್ದು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಎಲ್ಲರಿಗೂ ಇದು ಅಪ್ಲೈ ಆಗತ್ತೆ ಅಂತಲ್ಲ. ಇಂಥ ಮ್ಯಾಟರ್ಸ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋವಾಗ ನಿಮ್ಗೆ ಬಿಸ್ನೆಸ್ ಅಕ್ಯುಮೆನ್ ಇರೋದು ಒಳ್ಳೇದು. ಇದು ಲೈಫ್ ಸ್ಕಿಲ್ ಆಗತ್ತೆ. ಇದಕ್ಕೆ ಎಮೋಷನಲ್ ಇಂಟೆಲಿಜೆನ್ಸ್, ಕಲ್ಚರಲ್ ಕಾಂಪಿಟೆನ್ಸ್ ಎರಡೂ, ಆಮೇಲೆ ಕೊಲಾಬ್ರೇಷನ್, 3 ಒಟ್ಟಿಗೆ ತಗೊಂಡ್ರೆ ಇದು ನಿಮ್ಗೆ ಕ್ಲೈಂಟ್ ರೆಫರ್ ಮಾಡಿರೋದು ನಿಮ್ಮ ಕ್ಲೈಂಟೇ ಇಲ್ಲದೆ ಇರ್ಬೋದು. ಬೇರೆ ಯಾವುದೋ ನೀವು ಒಂದು ಊರಲ್ಲಿ ಇದ್ದೀರಾ, ಇನ್ನೊಂದು ಊರಿಂದ ನಿಮ್ಗೆ ರೆಫರ್ ಮಾಡಿರ್ಬೋದು. ಆ ರೆಫರ್ ಮಾಡಿದಾಗ ಆ ಅಡ್ವೊಕೇಟ್ ಜೊತೆ ಹೆಂಗ್ ಕೊಲಾಬ್ರೇಟ್ ಮಾಡ್ತೀರಾ, ಅವ್ರ ಜೊತೆ ಹೆಂಗೆ ಸಹಕರಿಸ್ತೀರಾ, ಅವ್ರು ಹೇಳಿದ್ದು ನಿಮ್ಗೆ ಹೆಂಗ್ ಅರ್ಥ ಆಗತ್ತೆ, ನೀವ್ ಹೇಳಿದ್ದು ಅವ್ರಿಗೆ ಹೆಂಗ್ ಅರ್ಥ ಆಗತ್ತೆ, ಆ ಕೊಲಾಬ್ರೇಷನ್ ಹೆಂಗಾಗತ್ತೆ. ಕ್ಲೈಂಟ್ ಗುಜರಾತಿಂದ ಇರ್ಬೋದು, ಗುವಾಹಟಿಯಿಂದ ಇರ್ಬೋದು, ಜಮ್ಮು ಅಂಡ್ ಕಾಶ್ಮೀರಿಂದ ಇರ್ಬೋದು. ಅಲ್ಲೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಕಲ್ಚರ್ಸ್ ಇರುತ್ತೆ. ಅವ್ರು ಅರ್ಥ ಮಾಡ್ಕೊಳೋದು ಬೇರೆ ಇರುತ್ತೆ. ಅವ್ರು ನಿಮ್ಮ ಹತ್ರ ಬಂದವಾಗ ನೀವು ಅವ್ರನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕಾ, ಅವ್ರು ನಿಮ್ಮನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕಾ, ಇಬ್ಬರನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕಾ ಅನ್ನೋದು ನೋಡ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ಅದು ಕಲ್ಚರಲ್ ಕಾಂಪಿಟೆನ್ಸ್, ಕೊಲಾಬ್ರೇಷನ್. ನಿಮ್ದು ಅಡಾಪ್ಟಬಿಲಿಟಿನೂ ಇರಬೇಕಾಗತ್ತೆ. ಅಲ್ಲಿ ನಮ್ಗೆ ಲೀಗಲ್ ಪ್ರೊಫೆಷನಲ್ ಅಂತೂ ಎಲ್ಲ ಲೈಫ್ ಲಾಂಗ್ ಲರ್ನಿಂಗ್, ದಿನ ಒಂದು ಕಲಿತಾ ಇರ್ತೀವಿ. ಅದಕ್ಕೆ ಓಪನ್ ಆಗಿರ್ಬೇಕು. ಇಲ್ಲ ನಂಗೆ ಎಲ್ಲ ಗೊತ್ತಾಗ್ಬಿಟ್ಟಿದೆ, ನಾನು ಇನ್ನೇನು ಕಲಿಯೋದು ಬೇಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ಏನೂ ಕಲಿಯೋಕ್ಕಾಗಲ್ಲ. ಸೊ ಕಲಿತಾ ಇರಬೇಕು. ನೀವು ಎಷ್ಟು ಬುಕ್ ಓದ್ರೇನು, ಎಷ್ಟಿದಾದ್ರೇನು, ನೀವು ನಮ್ಮ ಪ್ರೊಫೆಷನ್ನ, ಒಂದೇ ಪ್ರೊಫೆಷನ್ನ ನೋಬಲ್ ಅಂಡ್ ಲರ್ನೆಡ್ ಪ್ರೊಫೆಷನ್ ಅಂತಾರೆ. ನೋಬಲ್ ಡಾಕ್ಟರ್ ಪ್ರೊಫೆಷನ್ ನೋಬಲ್ ಇದೆ, ಬಟ್ ಅದು ಲರ್ನೆಡ್ ಅನ್ನಲ್ಲ. ಲರ್ನೆಡ್ ಯಾಕೆ ನಮ್ದು ಅಂತಾರೆ ಅಂದ್ರೆ, ನಾವು ಓದ್ತೀವಿ, ನಾವು ಓದಬೇಕು ಅಂತ ಒಂದು ಪ್ರಿಸಂಪ್ಷನ್ ಇದೆ. ನಾವು ಓದಿ ಎಲ್ಲ ತಿಳ್ಕೊಂತೀವಿ, ಇದು ತಿಳ್ಕೊಂಡಿದ್ರಿಂದ ನಮ್ದು ಲರ್ನೆಡ್ ಪ್ರೊಫೆಷನ್ ಅಂತಾರೆ. ಸೊ ಅದಕ್ಕೆ ಲೈಫ್ ಲಾಂಗ್ ಲರ್ನಿಂಗ್ ನಮ್ದು. ಇವಾಗ ನಿಮ್ಮ 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 ಕೋರ್ಟಲ್ಲಿ ಫೈಲಿಂಗ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಫೈಲಿಂಗ್ ಯೂಸ್ ಮಾಡಕ್ಕೆ ನಿಮ್ಗೆ ಫೈಲಿಂಗ್ ಹೆಂಗೆ ಮಾಡಬಹುದು ಅಂತಾನು ಕಲ್ತ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ಅದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ಕ್ಯಾನಿಂಗ್ ಕಲ್ತ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ಡಾಕ್ಯುಮೆಂಟ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಸಾಫ್ಟ್ವೇರ್ ಅಂದ್ರೆ ವರ್ಷನಿಂಗ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನೀವು ಫಸ್ಟ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಿರ್ತೀರಾ, ಇನ್ನೊಂದು ಡ್ರಾಫ್ಟ್ ಮಾಡಿರ್ತೀರ, ಅದರಲ್ಲೇ ಮಾಡಿದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಬೇರೆ ಇನ್ನೊಂದ್ಸರಿ ಸೇವ್ ಮಾಡಿದ್ರೆ, ಸಪೋಸ್ ಅರ್ಲಿಯರ್ ಡ್ರಾಫ್ಟ್ ನೀವು ಅಪ್ಲೋಡ್ ಮಾಡಿಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. ಸೊ ಅದನ್ನ ನೀವು ನೋಡ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಗ್ನೇಚರ್ ಬರುತ್ತೆ. ಇವಾಗ ಏನು ಫಿಸಿಕಲ್ ಸಿಗ್ನೇಚರ್ ಏನು ಮಾಡ್ತಾ ಇದೀವಿ, ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಗ್ನೇಚರ್ ಬರುತ್ತೆ. ನಾಳೆ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ನೋಟ್ರೈಸೇಷನ್ ಬರುತ್ತೆ. ಡಿಜಿಟಲ್ ಸೆಕ್ಯೂರಿಟಿನೂ ನೋಡ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ಅಂದ್ರೆ ನೀವು ಅದೇನು ಅಂತ ಬೇಡ, ಅದನ್ನ ಬರೀ ಅಳವಡಿಸ್ಬೇಕಾಗತ್ತೆ. ಈ ಸ್ಮಾರ್ಟ್ ಫೋನ್ ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಅದರಲ್ಲಿ ಹೆಂಗೆ ನೀವು ವಾಟ್ಸ್ಆ್ಯಪ್ ಯೂಸ್ ಮಾಡ್ಬೋದು ಅಂತ ಗೊತ್ತು. ವಾಟ್ಸ್ಆ್ಯಪ್ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಟೆಲಿಗ್ರಾಮ್ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಜಿಮೇಲ್ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಯೂಸ್ ಮಾಡೋದು. ಸೊ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಗ್ನೇಚರ್ ಅಂತಾನೂ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಬರುತ್ತೆ, ಅದನ್ನ ಯೂಸ್ ಮಾಡಿ ಸೈನ್ ಮಾಡಬೇಕು ಅಷ್ಟೇ. ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸಿಂಗು ಇವಾಗ ಎಲ್ಲ ಕಡೆ ಹೈಬ್ರಿಡ್ ಆಗ್ತಾ ಇದೆ. ಎಲ್ಲ ಕಡೆ ನಾವು ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ, ಬೆಂಗಳೂರಲ್ಲಿ ಹೈಕೋರ್ಟ್ಗಳಲ್ಲಿ ಯಾರಾದರೂ ಹೆಂಗಾದ್ರೂ ಹೈಬ್ರಿಡ್ ಆದ್ರೂ ಬರ್ಬೋದು, ಫಿಸಿಕಲಿ ಆದ್ರೂ ಬರ್ಬೋದು. ಸೊ ನೀವು ಆಫೀಸಲ್ಲಿ ಇದ್ಕೊಂಡು ನೀವು ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು. ಬಟ್ ಇದ್ರಲ್ಲಿ ಒಂದು 2-3 ವಿಷಯಗಳು ನಾನು ತಿಳಿಸ್ಬೇಕು. ಅಂದ್ರೆ ನೀವು ಹೆಸರು ಹಾಕಲ್ಲ, ನಿಮ್ಮ ಹೆಸರುಗಳು ಹಾಕಲ್ಲ. ಆ ಫೋನ್ ಹೆಸರು ಬಂದ್ಬಿಡುತ್ತೆ, iPhone 12, ಸ್ಯಾಮ್ಸಂಗ್ ಅಂತ. ನಿಮ್ಮ ಹೆಸರು ಹಾಕಿ. ಪ್ರೊಫೈಲ್ ಪಿಕ್ಚರ್ ಏನೇನೋ ಇರುತ್ತೆ, ಪ್ರೊಫೈಲ್ ಪಿಕ್ಚರ್ ಬೇಡ, ಬ್ಲ್ಯಾಂಕ್ ಇಟ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಒಳ್ಳೆ ಪಿಕ್ಚರ್ ಹಾಕಿ, ನಿಮ್ಮ ಹೆಸರು ಇಟ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಇದು ಲೈಟಿಂಗ್ ಕರೆಕ್ಟಾಗಿ ನಿಮ್ಮ ಮೇಲೆ ಇರಲಿ, ಸೊ ನೀವು ಯಾರು ಅಂತ ಗೊತ್ತಾಗತ್ತೆ. ಇವೆಲ್ಲ ಸಿಂಪಲ್ ಥಿಂಗ್ಸ್ ನಿಮ್ಗೆ ಗೊತ್ತಾದ್ರೆ ನಿಮ್ಮ ಹೆಸರು ಇದ್ಬಿಟ್ಟು ಕರೆಕ್ಟಾಗಿ ಜಡ್ಜು ನಿಮ್ಮ ಹೆಸರು ಕರಿಬಹುದು. ನೀವು ಕರೆದಾಗ ನೀವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿಕೊಂಡು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು. ಪ್ರೆಸೆಂಟೇಷನ್ ಮಾಡಬೇಕಾಗ್ಬೋದು. ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಒಂದು ಜಾಗದಲ್ಲಿಂದ ಇನ್ನೊಂದು ಜಾಗದಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋವಾಗ ನೀವು ಒಂದು ಎಕ್ಸಿಬಿಟ್, ಯಾವ ಎಕ್ಸಿಬಿಟ್ ನೀವು ಪ್ರೆಸೆಂಟ್ ಮಾಡಬೇಕು, P12 P13 ಅಂತ ಅಲ್ಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ವಿಜುವಲೈಸರ್ ಹಾಕಿದ್ರೆ ಎಲ್ಲರಿಗೂ ಕಾಣತ್ತೆ. ಅದನ್ನ ಹೆಂಗ್ ಯೂಸ್ ಮಾಡೋದು ಅಂತ ತಿಳ್ಕೊಳ್ಬೇಕು. ಇಂಥದ್ದಿದೆ, ಅದನ್ನ ಹೆಂಗ್ ಯೂಸ್ ಮಾಡೋದು ಅಂತ. ಕ್ಲೌಡ್ ಕಂಪ್ಯೂಟಿಂಗ್ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ, ವರ್ಚುವಲ್ ಪ್ರೈವೇಟ್ ನೆಟ್ವರ್ಕ್ ಆಗುತ್ತೆ, ಇವೆಲ್ಲ ನಿಮ್ಗೆ ತಿಳ್ಕೊಳ್ಬಹುದು. ಇದರಲ್ಲಿ ಏನು ಒಂದು ಈ ಕಮಿಟಿ, ನೀವು ಟೆಲಿಗ್ರಾಮ್ ಚಾನಲ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಈ ಕಮಿಟಿ ಅಂತ ಸರ್ಚ್ ಮಾಡಿ. ಅಲ್ಲಿ ಸರ್ಚ್ ಮಾಡಿದ್ರೆ ಈ ಕಮಿಟಿ ಪಬ್ಲಿಕ್ ಚಾನಲ್ ಅಲ್ಲಿ ಬಹಳ ವಿಡಿಯೋಗಳಿದಾವೆ, ಮ್ಯಾನ್ಯುವಲ್ಗಳಿದಾವೆ. ಆ ಮ್ಯಾನ್ಯುವಲ್ ನೀವು ಓದಿದ್ರೆ ನಿಮ್ಗೆ ಹೆಂಗ್ ಯೂಸ್ ಮಾಡ್ಬೋದು ಅಂತ ತಿಳ್ಕೊಳ್ಬಹುದು. ಹೆಂಗ್ ವಿಡಿಯೋಗಳು ಓದಿದ್ರೆ, ವಿಡಿಯೋಗಳು ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ ಹೆಂಗ್ ಯೂಸ್ ಮಾಡಬಹುದು ಅಂತಾನು ತಿಳ್ಕೊಳ್ಬಹುದು. ಇವೆಲ್ಲ ಒಂದು ಹನಿಗಳು. ಈ ಹನಿಗಳೆಲ್ಲ ಸೇರಿದ್ರೆ ಹಳ್ಳ. ಸೊ ಇದನ್ನ ನೀವು ಯೂಸ್ ಮಾಡಿದ್ರೆ, ಇದನ್ನ ಈ ಫಸ್ಟ್ ಟಾಕ್ ಇದ್ದಿದ್ದು ಇವಾಗೆಲ್ಲ ನಿಮ್ಗೆ ಇವು ಇದಾವೆ ಅಂತ ಹೇಳೋಕೆ ಇವಾಗ ಸ್ವಲ್ಪ ಯೋಚನೆ ಮಾಡಿದ್ಮೇಲೆ ಅಲ್ಲಿ ಒಂದೊಂದೇ ಬೇರೆ ಬೇರೆ ಬಸವರಾಜ್ ಅವರು ಒಬ್ಬೊಬ್ಬರನ್ನೇ ತಗೊಂಡು ಕರ್ಕೊಂಡು ಈ ಫೈಲ್ ಹೆಂಗ್ ಮಾಡ್ಬೋದು ಅಂತ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿಸ್ಬೋದು, ಹೆಂಗೆ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸಿಂಗ್ ಮಾಡ್ಬೋದು ಅಂತ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೋದು. ಇವೆಲ್ಲ ನಾನು ಬರೀ ಇಂಥವಿದೆ, ಇವೆಲ್ಲ ನೀವು ಕಲ್ತ್ಕೊಂಡ್ರೆ ಇದೆಲ್ಲ ಲೈಫ್ ಸ್ಕಿಲ್ಸ್, ನಿಮ್ ಜೀವನಕ್ಕೆ ಉಪಯೋಗ ಆಗಂಥದ್ದು ನಾಳೆ. ಯಾಕೆಂದ್ರೆ ಇವಾಗ ಟೆಕ್ನಿಕಲ್ ಪೇಪರ್ಲೆಸ್ ಕೋರ್ಟ್ ಹೊಡ್ತಾ ಇದೀವಿ. ಆ ಹೊರಡವಾಗ್ಲೇ ಇವೆಲ್ಲ ನಾವು ತಿಳ್ಕೊಂಡ್ರೆ ಲೈಫು ಬಹಳ ಈಸಿ ಆಗತ್ತೆ, ಸಿಂಪಲ್ ಆಗತ್ತೆ ಅಂತ ಇವೆಲ್ಲ ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು. ಇವತ್ತೆ ಎಲ್ಲ ಇವಾಗ್ಲೇ ಬೇಕು ಅಂತಲ್ಲ, ಯಾರು ಎಷ್ಟು ಬೇಗ ತಿಳ್ಕೊಂಡ್ರೆ ಅಷ್ಟು ಬೇಗ ಒಳ್ಳೇದು. ಸುರೇಶ್, ಕನ್ನಡನೂ ಆಯ್ತು.
ಎಸ್ ಸರ್.
ಓಪನ್ ಫಾರ್ ಕ್ವೆಶ್ಚನ್ಸ್.
ಎಸ್ ಸರ್. ಶೇರಿಂಗ್ ಆಪ್ಷನ್ ತೆಗೆದ್ಬಿಡ್ತೀನಿ ಸರ್. ಶೇರಿಂಗ್ ತೆಗೆದ್ಬಿಡುವ ಸರ್. ಎಸ್ ಸರ್, ಎಸ್ ಸರ್, ಎಸ್ ಸರ್. ಸ್ನೇಹಿತರೆ, ಇದುವರೆಗೂ ಕೂಡ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಅದ್ಭುತವಾಗಿ ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳಲ್ಲಿ ಯಾವ ರೀತಿಯಾಗಿ ತಂತ್ರಜ್ಞಾನವನ್ನ ಬಳಸಬೇಕು, ಯಾವ ರೀತಿಯಾಗಿ ನಮ್ಮ ಭಾವನೆಗಳು ವ್ಯಕ್ತಪಡಿಸಬೇಕು ನ್ಯಾಯಾಧೀಶರ ಮುಂದೆ, ಮತ್ತೆ ಕೋರ್ಟ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿರ್ತಕ್ಕಂಥ ಸಿಬ್ಬಂದಿ ಜೊತೆಗೆ, ನಮ್ಮ ಕಕ್ಷಿದಾರರ ಜೊತೆಗೆ, ಮತ್ತೆ ನಮ್ಮ ಜೊತೆಗೆ ಬಂದಂತ ವಕೀಲರ ಜೊತೆಗೆ ಯಾವ ರೀತಿಯಾಗಿ ನಾವು ವರ್ತಿಸಬೇಕು ಅನ್ನೋದನ್ನ ಅದ್ಭುತವಾಗಿ ಮತ್ತು ಅತ್ಯಂತ ಸರಳವಾಗಿ ಹೇಳಿದ್ದಾರೆ. ನೋಡಿ, ಬಾರ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಇಂಡಿಯಾ ರೆಗ್ಯುಲೇಷನ್ಸ್ ನಲ್ಲಿ ಪ್ರತಿ ವಕೀಲರಿಗೆ 3 ಕರ್ತವ್ಯಗಳಿರ್ತದೆ: ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ಕೋರ್ಟ್, ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ಕ್ಲೈಂಟ್ ಅಂಡ್ ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ಫೆಲೋ ಅಡ್ವೊಕೇಟ್. ಇದನ್ನ ಅತ್ಯಂತ ಸರಳವಾಗಿ ಮತ್ತು ಎಲ್ಲರಿಗೂ ಅರ್ಥವಾಗುವ ರೀತಿಯಲ್ಲಿ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಹೇಳಿದ್ದಾರೆ. ಈಗ ಪ್ರಶ್ನೆ ಮತ್ತು ಉತ್ತರ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ನಾನು ಮಾಡ್ಲಿಕ್ಕೆ ಅನುವು ಮಾಡಿಕೊಡ್ತೀನಿ. ದಯವಿಟ್ಟು ಅನಗತ್ಯ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಬಾರ್ದಾಗಿ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿ. ತಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿಕೊಂಡು ಮತ್ತು ವಿಡಿಯೋ ಆನ್ ಮಾಡಿಕೊಂಡು ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಬಹುದು. ಮತ್ತೆ ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಹೇಳ್ತೀನಿ ಸರ್, ತಮ್ಮ ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ನನ್ನ ವಿಡಿಯೋ ಆಫ್ ಆಗಿದೆ, ಆನ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ, ನೀವೇ ಮಾಡ್ಬೇಕು.
ಈಗ ಮಾಡಿ ಸರ್. ಈಗ ಇದಕ್ಕೆ ಮರೆಯೋದಕ್ಕಿಂತ ಮುಂಚೆ, ಮೊನ್ನೆ ತಿಪಟೂರಿನಲ್ಲಿ ನಡೆದ ಕಾನೂನು ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ತಂತ್ರಜ್ಞಾನದ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಒಂದು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನ ನೀಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ನ್ಯಾಯಾಲಯ ಕಲಾಪಗಳಲ್ಲಿ ತಂತ್ರಜ್ಞಾನ ಮತ್ತು ಈಗ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಬದಲಾವಣೆಗಳು ಏನು ತರಲಾಗಿದೆ, ಇದನ್ನ ಅತ್ಯಂತ ವಿಶದವಾಗಿ ತಿಪಟೂರಿನ ಕಾನೂನು ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನು ಕೂಡ ನಾನು ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. ಅದನ್ನ ಎಲ್ಲರಿಗೂ ನಾನು ಪ್ರಚಾರ ಪಡಿಸ್ತೇನೆ. ದಯವಿಟ್ಟು ಅದನ್ನ ನೋಡಿ. ಇದಕ್ಕಿನ್ನ ಇವತ್ತು ಕೊಟ್ಟಂತ ಮಾಹಿತಿಯ ಜೊತೆಗೆ ಇನ್ನ ಅತ್ಯಂತ ಹೆಚ್ಚಿನ ಮಾಹಿತಿಯನ್ನು ಕೂಡ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ತಮ್ಮ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಬಹುದು, ತಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೋಬಹುದು. ಮತ್ತೆ
2 ಕ್ವಶನ್ ಇದೆ, ಅದು ಫಸ್ಟ್ ಅದು ಆನ್ಸರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಎಸ್ ಸರ್, ಎಸ್ ಸರ್.
ಆನಂದ್ ಅವರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಥರ್ಡ್ ಫೇಸ್ ಅಲ್ಲಿ ಯಾವಾಗ ಟೈಮ್ ಲೈನ್ when we'll see the whole scale implementation of paperless court with e-filing mechanism and e-notice procedures. The third phase is started now, which will start now in probably June. Now the first phase was from 2006 to 2014-15, and second phase from 2015 to now, and third phase from now on for another 4 years. The first phase budget was 900 crores. Second phase budget was 1,600 crores. The third phase budget is 7,200 crores. So it is 10 zeros after 7. So that is the kind of budget which is there, but the work which is required to be done in all states is a large amount of work. It'll take some time, but it will happen in phases. Every year, all the aspects have been. For example, if you look at E-Seva Kendra, there are 4,400 E-Seva Kendras to be established in this phase. There are 1,000 paperless courts to be established every year for the next for the first year, 1,000 for the next, 1,000 for the next, 3,000 for the last phase. Virtual hearing, 18,000 courts are to be virtual courts, hybrid courts in the so all these will start now. Once the money starts coming in, the money will start coming in probably in June. We should see large scale implementation very shortly. Insofar as e-notice proceedings, procedure, etc. is concerned, there are N-step is already available. N-step has been introduced in the state of Karnataka. N-step could be used. We also are carrying out some amendments to the CPC, which will allow probably email services. Once that is enabled, services could happen by email. ಇವಾಗ ಕನ್ನಡದಲ್ಲಿ ಹೇಳಬೇಕು ಅಂದ್ರೆ ಈ ಥರ್ಡ್ ಫೇಸ್ ಇರೋದು 7,200 crore ಬಜೆಟ್ ಇದೆ, 7,200 ಕೋಟಿ. ಸೊ ಇದು 4 ವರ್ಷದ ಪ್ರಾಜೆಕ್ಟ್. ಈ ವರ್ಷ ಶುರು ಮಾಡಿದ್ರೆ ಇನ್ನು 4 ವರ್ಷದ ಒಳಗೆ ಕಂಪ್ಲೀಟ್ ಮಾಡಬೇಕು ಅಂತ. ಎಲ್ಲ ಕೋರ್ಟ್ಗಳು ಎಲ್ಲ ಕೋರ್ಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್ ಅಲ್ಲೂ ಒಂದು E-Seva ಕೇಂದ್ರ ಇರುತ್ತೆ ಟು ಅಸಿಸ್ಟ್ ಯಾರ ಹತ್ರ ಕಂಪ್ಯೂಟರ್ ಇಲ್ವೋ, ಯಾರ ಹತ್ರ ಡಿಜಿಟಲ್ ಡಿವೈಡ್ ಇದೆ, ಯಾರು ನಾನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತಿದ್ಯೋ, E-Seva ಕೇಂದ್ರ ವಿತ್ ಕಂಪ್ಲೀಟ್ ಎಲ್ಲ ಮಾಧ್ಯಮಗಳು, ಸ್ಕ್ಯಾನರು, ಕಂಪ್ಯೂಟರು, ಪ್ರಿಂಟರು ಎಲ್ಲ ಇರುತ್ತೆ ಅಲ್ಲಿ. ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಫೈಲ್ ಮಾಡ್ಬೋದು. 4,400 E-Seva ಕೇಂದ್ರಗಳು ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗ್ತಾ ಇದೆ ಥ್ರೂ ಔಟ್ ಇಂಡಿಯಾ. ಎವ್ರಿ ಕೋರ್ಟಲ್ಲಿ ಒಂದು E-Seva ಕೇಂದ್ರ ಇರುತ್ತೆ. ಪೇಪರ್ಲೆಸ್ ಕೋರ್ಟ್, ಆನ್ಲೈನ್ ಕೋರ್ಟ್ಸ್, ಹೈಬ್ರಿಡ್ ಕೋರ್ಟ್ಸ್, ವರ್ಚುವಲ್ ಕೋರ್ಟ್ಸ್. ಇವಾಗ ಬೆಂಗಳೂರಲ್ಲಿ ವರ್ಚುವಲ್ ಕೋರ್ಟ್ಸ್ ಫಾರ್ ಟ್ರಾಫಿಕ್ ಅಫೆನ್ಸಸ್ ಮಾಡಿದ್ದೀವಿ. ಅದೇ ತರ ಈಚ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ ಒಂದು ವರ್ಚುವಲ್ ಕೋರ್ಟ್ ಆಗ್ಬೋದು. ಸೊ ಅದನ್ನು ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗುತ್ತೆ. ಇನ್ನ ಒಂದು ಕ್ವೆಶ್ಚನ್ ಇರೋದು ಪ್ರಜ್ಞಾ ಅವ್ರದ್ದು ಈ ಫೈಲಿಂಗ್ ಅಲ್ಲಿ ಇವಾಗ ಎಸ್, ಬೇರೆ ಬೇರೆ ಕೋರ್ಟು, ಡಿಫ್ರೆಂಟ್ ಕೋರ್ಟ್ಸ್ ಹ್ಯಾವ್ ಹ್ಯಾಡ್ ಡಿಫ್ರೆಂಟ್ methodologies of e-filing and requirements of e-filing. Now the e-filing version 3.0 will be introduced shortly, which will probably standardize the requirements of filing, because until now each court, depending on the progressive nature of that court, has come up with its own e-filing. Going forward with e-filing 3.0, the paper size, the spacing, everything will be standardized. Those were the questions in on the can there be indicated?
Somebody asked the question which I wanted to ask, the impact of the artificial intelligence. Now there is a big uproar.
ಬರ್ತೀನಿ ಅದಕ್ಕೆ. ಇವಾಗ ಸುಪ್ರೀತ್ ಅವ್ರು
already predicting the Armageddon.
ಸುಪ್ರೀತ್ ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು ಇಂಡಿಕೇಶನ್ ಆಫ್ ಟೈಮ್ ಲೈನ್ ಟು ಡಿಜಿಟೈಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್, ನಾಟ್ ಜಸ್ಟ್ ಡೆಪೋಸಿಷನ್ ಬಟ್ ಎಕ್ಸಿಬಿಟ್, ಸ್ಕ್ಯಾನಿಂಗ್ ಅಂಡ್ ಅಪ್ಲೋಡಿಂಗ್ ವಾರ್ಡರ್ ಶೀಟ್, linking TC judgment, etc. while filing appeal on. Are we looking at doing away with paper books in the okay? Supreet avardu bada important question adu. The digitization of files is two pronged. One is ನಮ್ಮ ಹತ್ರ ಇರೋದು whatever is existing with us, we need to digitize those files in terms of the legacy files, disposed files. The idea now is to digitize all the pending files, at least 10 plus years, and see that everything is digitized. But also we cannot have a situation where the new filing is done by paper and the old filing we digitize, because that will be now at this stage. Let me ask this question. From 2015 to 2022, Can you guess how many cases were filed in the district courts of the country? You can type it in if you want.
All over the country, sir.
All over the country.
More than 5 lakh?
5 lakhs, sir. ನೀವೆಲ್ಲೋ ಇದ್ದೀರಾ ನಮ್ಮ ಲಾಯರ್ ಕೆಲಸ ಹೆಂಗ್ ಬರೀ 5 lakh ಇದ್ರೆ
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೆವೆಲ್
ಇಲ್ಲ ನಾವು ಕರ್ನಾಟಕ ಅಲ್ಲ ನಾನು ಆಲ್ ಓವರ್ ದ ಕಂಟ್ರಿ.
ಓ ಶ್ರೀಧರ್ ಪ್ರಭು 2 crores ಅಂತಿದ್ದಾರೆ.
ಶ್ರೀಧರ್ ಪ್ರಭು 2 crores ಎಲ್ಲಿದಾರೋ ಗೊತ್ತಿಲ್ಲ. ಅವ್ರು ಬರೀ ಆಪ್ಟೆಲ್ ಅಲ್ಲಿ 2 ಕೋಟಿ ಅನ್ಕೊಂಡಿರ್ಬೇಕು ಅವರು. The filing from 1st January 2015 to 31st December 2022 was 11 crore 95 lakh cases. Not a small number. It is 11 crore 95 lakhs was in the district judiciary. In the high courts, it was 77 lakh cases which were filed. These are all data points that we need to be aware of to see what decision-making process can happen. You have 11 crore 95 lakhs. How many cases do you think were disposed of by the judiciary? Now you know how much was filed. So tell me how many were disposed.
About 6 crore.
Any other response?
50%, sir. 50% of the cases.
You underestimate lawyers and judiciary.
ಮಧ್ಯೆ ಕೋವಿಡ್ ಬಂತಲ್ಲ ಸರ್.
ಕೋವಿಡ್ ಅಲ್ಲಿ ಫೈಲು ಆಯ್ತು, ಕೋವಿಡ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. 9 crore 95 lakh cases were disposed.
Horrible.
So if you look at it, 11 crore 95 filing, 9 crore 95 disposed. High Court only 77 lakhs, only 67 lakhs were disposed. These are the figures which are available on NJDJ site. This is not a figure that I am giving you. This is a figure which is available on NJDJ sites. I can show you the graphs also if you want. But now, this is the kind of filing. So when this kind of filing happens, it is required that whatever comes in electronically. We won't be able to cater to what is estimated is 3,200 crore pages are to be digitized for legacy records. The budget of nearly around 2,200 crores for that. So this is going to start. All the courts will have to get up to do the digitization of the records. Now, that having said, as again I was saying, all of you lawyers should look at e-filing so that everything comes digital. It is only then that we can have what Mr. Supreet is asking for, that we'll have the deposition, the exhibits, order sheets are already there, deposition is already there, judgments are there, exhibits baratte. If you file an appeal from a municipal court to a district court, RA is filed, you only would probably have to file the appeal memo. Everything else, because it is digitized, appeal memo in a digital format you file, everything which is digitized will come and link up to the appeal file. You don't need to file anything. We are also doing translation. All the Supreme Court Vidhi Anuvadak software is used for translating judgments from English to Kannada, etc. Probably at some point in time, it may, once it is trained properly, it will be available for everybody that you can put in a document and it will translate it for you real time. If that happens, if there's a translation required, that will happen on the fly. Real time ಅಲ್ಲಿ ಯಾವಾಗ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ತಿರೋ ಅದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಆಗುತ್ತೆ. ಅದಾದಾಗ in the when it goes to the Supreme Court, everything could be translated into English and it be filed. Even in Supreme Court, you just need to file the special leave petition, nothing more. Supreet has asked a lot of questions in one question. Are we looking at doing paper book? Yes, paper book could be done away with if we follow this. Digitization, economically driven option, which may not be an option for some young lawyers from modest background. That is the reason why we'll be having e-Seva Kendras. Each court complex will have a e-Seva Kendra, 1. 2, there is also called the Citizen Service Center. established by the government of India. There are about 1 lakh citizen service centers in the country. In our own state, Nammalli, Namma Sarkara, Karnataka Sarkara has also established Grama 1. ಎಲ್ಲ ಗ್ರಾಮದಲ್ಲೂ ಒಂದೊಂದು ಗ್ರಾಮ ಒನ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಬೇಕು ಅಂತ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಇದೆ. ವಾಟ್ ವಿಲ್ ಆಲ್ಸೋ ಬಿ ಡೂಯಿಂಗ್ ಇಸ್ ದಟ್ ವಿಲ್ ಬಿ ಟೈಯಿಂಗ್ ಅಪ್ ವಿತ್ ಆಲ್ ದೀಸ್ ಪೀಪಲ್ ದಟ್ ಯಾರಿಗೆ ಈ CSC ಸೆಂಟರ್ಗೆ ಹೋಗ್ಬೋದು, ಗ್ರಾಮ ಒನ್ಗೆ ಹೋಗ್ಬೋದು, ಈ ಸೇವಾ ಸೆಂಟರ್ಗೆ ಹೋಗ್ಬೋದು, ಅಲ್ಲಿಂದ ಆಲ್ ದಿ ಏನು ಈ ಫೈಲಿಂಗ್ ಮಾಡ್ಬೋದು, ಏನು ಅಪ್ಲೋಡ್ ಮಾಡಬೇಕು ಅಲ್ಲಿಂದಾನೇ ಮಾಡ್ಬೋದು. ಸ್ವಿಚ್ ಆನ್ ವಿಡಿಯೋ ಆರ್ ಕಮ್ಲೈ. ಓಕೆ, ಅದು ಸುಪ್ರೀತ್ ಅವ್ರದ್ದು ಆಯ್ತು. ವುಡ್ ದೇರ್ ಬಿ ಅ ಟೈಮ್ ಇನ್ ದ ಫ್ಯೂಚರ್ ವೆನ್ VC will become a reality in trial courts? Trial courts already we have started it, and much of the equipment has also been ordered. Very shortly, all the trial courts would probably be having VC facilities. Not only trial courts, the idea is that even quasi-judicial AC, DC, Tahsildar or Mundenu, there should be designated days for quasi-judicial functions where it is conducted through VC. So most probably in a very short time from now, we'll have all proceedings through video conferencing. ನೀವು ಆಫೀಸಲ್ಲೇ ಕೂತ್ಕೊಂಡು, ನಿಮ್ಮ ಆಫೀಸಲ್ಲೇ ಕೂತ್ಕೊಂಡು, ಇಲ್ಲ ನಿಮ್ಮ ಹೋಮ್ ಆಫೀಸ್ ಇದ್ರೆ ಹೋಮ್ ಆಫೀಸಲ್ಲೇ ಕೂತ್ಕೊಂಡು, subject to complying with noise in the background, your video, etc. being proper, you could conduct proceedings sitting at home. Sridhar Prabhu, could you guide us on the impact of artificial intelligence on our profession and legal milieu in general? Artificial intelligence is a oxymoron. Oxymoron ಅಂದ್ರೆ ಎರಡು ವರ್ಡ್ ಯಾವಾಗ ತಗೊಂಡಿರೋ ಜೊತೆ ಎರಡೂ ಜೊತೆ ಎಕ್ಸಿಸ್ಟ್ ಆಗಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಅಂತ ಬರುತ್ತೆ. ಆರ್ಟಿಫಿಷಿಯಲ್ಲು ಇಂಟೆಲಿಜೆನ್ಸ್, ಆರ್ಟಿಫಿಷಿಯಲ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಇಂಟೆಲಿಜೆನ್ಸ್ ಇರಕ್ಕಾಗತ್ತಾ ಅಂತ ಅನ್ಕೊಂತೀವಿ. ಬಟ್ ಇವಾಗ ಆರ್ಟಿಫಿಷಿಯಲ್ ಇಂಟೆಲಿಜೆನ್ಸ್ are all tools which are being used. ಇವಾಗ ಚಾಟ್ GPT ಅಂತ ಬಂದಿದೆ. ಇವಾಗ ಚಾಟ್ GPT ಬೇಕಾದ್ರೆ ನಾನು ತೋರಿಸ್ಬೋದು ನಿಮ್ಗೆ, ಕ್ವಶನ್ಸ್ ಕೇಳಿದಾಗ ತೋರಿಸ್ಲಾ ಅದು?
ಎಸ್ ಸರ್.
ಎಸ್ ಸರ್.
ತಿಪಟೂರಿನಲ್ಲಿ ನಡೆದ ಕಾರ್ಯಕ್ರಮದ ಯೂಟ್ಯೂಬ್ ಲಿಂಕ್ ಅನ್ನು ಹಾಕಿದ್ದೀನಿ, ದಯವಿಟ್ಟು ಅದನ್ನ ತಾವು ಸೇವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅದರಲ್ಲಿ ಇದರಷ್ಟೇ ಮಾಹಿತಿಯನ್ನ ನ್ಯಾಯಾಂಗದಲ್ಲಿ ತಂತ್ರಜ್ಞಾನದ ಬಗ್ಗೆ ನ್ಯಾಯಮೂರ್ತಿಗಳು ನೀಡಿದ್ದಾರೆ.
ಚಾಟ್ GPT?
ಎಸ್ ಸರ್.
ಚಾಟ್ GPT ಅಲ್ಲಿ ಏನಾದ್ರು ಒಂದು ಕ್ವಶನ್ ಕೇಳಿ, ವಾಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಸ್ಪೆಸಿಫಿಕ್ಲಿ ಲೀಗಲ್ ಅಲ್ಲ, ಬಟ್ ಏನಾದ್ರು ಲೀಗಲ್ ಕ್ವಶನ್, ಜನರಲ್ ಲೀಗಲ್ ಕ್ವಶನ್ ಕೇಳ್ಬೋದು ಇದಕ್ಕೆ.
ವೆದರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬೆಂಚ್ ಇನ್ ಸೌತ್ ಇಂಡಿಯಾ ಈಸ್ ಅಡ್ವೈಸಬಲ್?
ಅದು ಬೇಡ, ಬೇರೆ ಏನಾದ್ರು ಕೇಳಿ. It may not be able to answer that kind. To answer you differently with online hearing and virtual hearing, why do you require benches anywhere?
ಕರೆಕ್ಟ್. ಅದು ನಾನು ಕ್ವಶನ್ ಒಂದ್ಸರಿ ಕೇಳಿದ್ದೆ, ಅದು ಸಿಕ್ಕಾಪಟ್ಟೆ ಚೆನ್ನಾಗಿ ಒಂದು ಆರ್ಟಿಕಲ್ ನ ಕೊಡ್ತು. ಅದಕ್ಕೆ ನಾನು ಏನ್ ಕೊಡುತ್ತೆ ಅಂತ, ಅವ್ರು ಈ ಸರಿ ಏನ್ ಕೊಡುತ್ತೆ ಅಂತ
ಬೆಂಚ್
ಸಿಸ್ಟಮೆಟಿಕ್ ಆಗಿ ಮಾಡ್ತದ್ದು ವಿತ್ extremely thought-provoking data and all it gave.
Good evening, sir. Just wanted to inform that today there was a news on bar and bench saying that particular Punjab and Haryana High Court referred to Chat GPT while deciding a bail petition.
Yes, that was done last week by Justice Anup Chitkara. He had asked for a question on bail jurisprudence across the world. So where there was a answer that he got from the Chat GPT, but he did not use that. It was a basis for reference. In fact, there was another judge from South America who had used it. To the question that he had asked was, could could a autistic child be exempted from making payment of the tuition fees? So these are all things that it could be used.
Or we can say adverse position in India. That's better, sir. Monthly, simple
Adverse
and,
position.
adverse position.
What is adverse position?
Yes. What is adverse position? That would be better. This is paid version, sir.
It's not paid version. This is a free version.
Yes, sir. Oh,
Paid version will be GPT-4.
this is unbelievable speed.
Adverse possession legal principle that allows a person to gain ownership of a piece of land by occupying it for a certain period of time, etc., etc. ನೀವೇ ಓದ್ಕೊಳ್ಬಹುದು.
Yes, sir. Yes, sir.
Read. Now, this is ChatGPT as data which is in the public domain. 175 petabytes of data. 1 petabyte is 1024 terabytes. And ನಮ್ಮಲ್ಲಿ 1 TB ಏನಂತೀವೋ ಅದು
2000 GB.
ನಮ್ಮ ಫೋನ್ ಅಲ್ಲಿ ಇರೋದು GB. 1024 GB is 1 terabyte. 1024 terabyte is 1 petabyte. So that is the kind of data on which it is trained. But these are all public domain, newspaper, articles, magazines. Those are the basis from which it is getting this information. Tomorrow, if we have a ChatGPT or anything that we call it, which is trained on only the legal data, ನಮ್ಮ ಎಲ್ಲ Supreme Court judgments are there, High Court judgments are there, ನಮ್ಮ acts and rules are there. If those are trained on that, we'll be getting proper answers for our reference. It may not be that it will replace, it may not be that we should not look at it that way, but it's a tool. When we had Manupatra, SEC, etc., which came in, it did not replace anybody. We asked for a search and it gave the search result of the judgments. It is a similar kind of a search, but it is a much larger, faster, and it's in your own, it's in a natural language that it comes across. So this is a much better version of research which could come about. We are also working on something called the Judicial Interactive Virtual Assistant, JIVA, where all the statutes, acts and rules will be fed in. And nimge Siri, Alexa, and then Alexa, give me section 34 of the Arbitration Conciliation Act, and it will give you the section 34. If you say, give me Arbitration Conciliation Act, and the Arbitration Conciliation Act, it will come about. Give me the difference or amendments carried out to section 34 from 2013 to 2022, and those amendments could come. These are things that can happen. These are things that people are working on. So if you get that data, you don't need to have barracks in your office. Nim barracks ella bekagilla, idella free ಆಗಿರುತ್ತೆ. ಇವಾಗ ನಿಮಗೆ ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ಸ್ ಫ್ರೀ ಆಗಿದೆ ರೆಪಾಸಿಟರಿಯಲ್ಲಿ. ಇಂಡಿಯಾ ಕೋಡ್ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ಸ್, ದಿ ಆಕ್ಟ್ಸ್ ಆರ್ ಫ್ರೀ, ರೂಲ್ಸ್ ಅಂಡ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಆರ್ ಫ್ರೀ. ನಾಳೆ ಅದು ಬಂದ್ರೆ ಇಟ್ ಜಸ್ಟ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಕನ್ಸಿಲೇಷನ್ ಆಕ್ಟ್ ಅಂತ ಕೇಳಿದ್ರೆ ಬರುತ್ತೆ. CPC ಅಂದ್ರೆ ಬರುತ್ತೆ. ಯಾವ ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ ಆಯ್ತು ಅಂತ ಅದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಬರುತ್ತೆ. ಇಂಥ ಕ್ವೆಶ್ಚನ್ಸ್ ಕೇಳಿದಾಗ ಇಂಥ ಆನ್ಸರ್ಸು ಬರುತ್ತೆ. So there are various implementations of artificial intelligence. For example, in Brazil, you would be surprised when I was interacting with a judge from Brazil. He told me that the filing that they have per annum is nearly around 30 million. That is 3 crore cases are filed every year. For a population of Brazil's size.
Yes, sir.
3 crore cases is huge. Nammallu ashtilla. Nammalli we are around 15-16 million, around 1.5 to 1.6 crores per year. Ali double ide. What they have done is they have implemented AI software called Victor Socrates anta. Victor, for example, nimge helbeku andre nammalli for a second appeal we have something called a substantial question of law. Brazil, they have they call it questions of general repercussion. So what they have done is all the judgments of the superior courts have been fed into it. And whenever a new RSA or that kind of second appeal gets filed, it does a search and finds out if that question has already been answered by the superior courts. If it's answered, there's nothing more in this. So at that stage only, it puts up a report saying this have been decided by so. So there is nothing to be decided on that. It is only if only if it is something which is required to be decided, it is put forth before the court. Therefore, it could be decided. Nammali esto RSA pending in the way, those could be disposed. MVC matters, we could use that for the purpose of, for example, if MVC, if we integrate who are the players, it is the police, it is the RTO, it is the hospital, and it could be it could be, these are the people who insurance company. ಎಲ್ಲಾನು integrate ಮಾಡಿಬಿಟ್ರೆ ಎಲ್ಲ ಡೇಟಾ ಅಲ್ಲಿಂದ fetch ಮಾಡಿದ್ರೆ the analysis could be easier. There are a lot of implementation which could be done by using artificial intelligence, which would be a tool. Don't look at replacement of a judge, replacement of a lawyer. These are all tools which could be used. Technology is a slave, not the master. We'll have to treat it as such. That is one part of it. The second part of it is that most of these could be used in the administrative. A lot of delays happen on the administrative side. Process fee not paid, copies not furnished, compliance not made. If these could be used at that stage by bringing in artificial intelligence, other tools, we can bring about efficiency in administration, thereby judicial efficiency. For example, 4 crore 30 lakh cases you are pending enidio. 1 crore 41 lakh cases are for appearance. They can't proceed until that appearance happens. So those are the things.
Sir, recently, your friend Justice Mohammed Mushtaq of the Kerala High Court, in a seminar conducted in Bangalore, he explained how at least the Motor Vehicles Act cases and the workman compensation cases can be referred to this ChatGPT and how it can be, synchronized with the data already available. This is the first step. At least the motor vehicle cases and workman compensation cases, I think that can be.
It could be, because if you look at my analysis, indicates that around 25 to 30% of the cases pending in each high court is MVC matters. So we can look at MVC matters, we could look at mandamus matters, we could look at these kind of matters which are repetitive matters. So for repetitive matters, this could help.
At least 60% of these cases are referred to Lok Adalat. Now, before Lok Adalat, just before matter goes to Lok Adalat, one note by the artificial intelligence, which is placed before the Lok Adalat judges, that would, I think, guide them to the fullest extent possible, according to me.
Absolutely. For example, we have telemedicine now, and we have artificial intelligence diagnosing on the basis of the symptoms and on the basis of the X-rays which are put up and the CAT scans, etc., which are put up. Now, if we have artificial intelligence which is used to determine the disability percentage, which is where a lot of time is spent, if the X-ray is put in and the doctor's reports are put in and the deficiency percentage is generated from it, saying it's 20%, 25%, 40%, 50%, would not that save a lot of time?
Of course, sir.
Otherwise, it's only a calculation. The liability in terms of whether there is contributory negligence, etc., is one part of it. Two is what is the, in death, it is very easy because there's already a death, there's no determination. But if it's an injury, even for a small injury, there's a lot of time which is required to be spent to ascertain the disability. So that could be avoided, or that could be speeded up. Priya is asking a question, what is the best way forward for final year law students? Which branch of law to pursue for fresh pass outs? Priya, this is something that you will have to decide for yourself as to what is it that you feel close to. You want to litigate, you will have to decide, I'm going to litigate. If you like to litigate, get into litigation. If you get like non-litigation work, you do that. It is something that you like, that you love. It is not something that anybody can advise you on. Nobody can advise you on that. We can only point you in some direction. But what you want to do, the next, you are all 22, 23, 24-year-olds. In the next 20 to 30 years, you'll be in this profession. So that 30 years, what do you want to do is what you have to decide. And if you take up something, you are not comfortable with it, don't bother, change over. 2 years later, you change over. It doesn't matter. 2 years is nothing in one person's life. If you are doing litigation, you want to do non-litigation, come out to non-litigation. If you're doing non-litigation, you want to come out to litigation, do that. Don't bother about that. There is no the right answer. You will have to be comfortable in what you are doing. Mr. Prashant Gowda is asking, how about developing a robust infrastructure using this? I've already answered. We could use ChatGPT by binding the data, all the data nammalli enideyo, ella data annu now sangrahisi, if we put it into ChatGPT, can work in islands, can work in the universe, can work in the metaverse. If we have an island for judiciary, if we have an island for litigation, that litigation only having judgment of the Supreme Court and the High Court of your particular state need not be the other state, because they are persuasive. Or you could have full bench decisions and division benches of the other state to have more persuasion. And this, it could be, and there is a possibility of using ChatGPT. ChatGPT is only one part of it. AI as an infrastructure, there are people working in the public domain in terms of NGOs called OpenAI, and you can go to OpenAI, NYAI.org, and so if you go there, you'll see a lot of implementation. There are a lot of people who are working on it. Even the IT minister is looking at establishing a center of excellence for AI, because AI is a very expensive affair, because people who are working on AI are expensive. So it requires a lot of investment.
Is there any effort, sir, that to develop that such a program that ChatGPT can get it connected? So, for example, now you give an example, adverse possession. Can it give the related judgments like footnotes, like from
for
SCR,
now,
ESCR?
You can ask for it. It may not be able to give it for now. Important judgments.
I tried, but the citations are not exhaustive. It gives some judgments, but they are not exhaustive like SEC case finder and all that. Sometimes it may not be up to date. So theoretically, yes.
There are until 2021, it can give you some of these, but we need to have data which is tailored for this. It's not a difficult task. It's not ChatGPT is one implementation. There'll be many other implementations. It's only a natural language model. NLM model can be implemented for judgments. And if you do it can even, why restricted to what you are asking? It can also give you where it has been referred to, relied upon, distinguished, overruled. Although it can, if you ask for a history of adverse possession, it will give the entire history. All that can happen. See, there's no limits to technology. Technology, it's available.
What is your take on casemind.com, sir?
Casemind is an excellent software. Casemind is excellent software. LegitQuest is excellent software which uses AI. It makes life of a lawyer easy to understand what particular aspects are there. But having said that, what I would request all lawyers to do is read the entire judgment. That one para which it throws up, on that basis you come and argue, then we see another para which is something else. It becomes a little difficult.
I think Casemind subscription is very expensive.
Expensive.
Yeah, 31,000.
The best according to me is the Supreme Court case finder. The best, given the scenario that it covers from 17th century almost to up to date.
Yes.
Sir, time fixed on argument get time slot.
This is what I wanted to. You read my mind. Who is this gentleman?
Mahesh Odeh.
Sir, this is what exactly I wanted to ask.
Mahesh Odere, when you appear, I'll fix time for you.
No, the 7 judges bench of the Kenya Supreme Court, they heard the argument regarding the basic structure of the Kenyan constitution. Now, the recent, just flip side of the coin is the recent argument before the Supreme Court in some political issue. Everybody going, lengthy arguments and all. In Kenya, the discipline was so much that one side was given about 1 hour. Within that 1 hour, the lawyers, they borrowed 10 minutes or 15 minutes from the other counterpart, their own advocate, their own side. And they completed the argument strictly. And there was a big clock in the court hall itself. Of course, it was a kind of a makeshift arrangement. But the discipline we experienced in the Kenyan Supreme Court or the High Court was amazing, sir.
Mr.
Because
Basant, let me put it
American
this
courts
way.
ನಲ್ಲಿ ಎಲ್ಲ time slot, county courts ನಲ್ಲಿ
Kenya,
time
forget
slot
about
fix
America. The
ಮಾಡಿದ್ದಾರೆ.
African country has adopted such a discipline.
No, look at
ಅದಕ್ಕೆ
where,
ನಮ್ಗೆ
ಹೇಳಿ ಒಡೆಯರ್ ಅವರೇ.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಮ್ಮಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ಟೈಮ್ ಸೇವ್ ಆಗುತ್ತೆ. ವಿ ಕ್ಯಾನ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದ ಪರ್ಟಿಕ್ಯುಲರ್ ಕೇಸ್ ಇನ್ ಅ ಪರ್ಟಿಕ್ಯುಲರ್ ಟೈಮಿಂಗ್ ಇದ್ರಲ್ಲಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಮ್ಯಾರಥಾನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ 2 ದಿವಸ 3 ದಿವಸ ಸುಮ್ಮನೆ ಅದು ಪಾಯಿಂಟ್ ವಿಲ್ ಬಿ ಎ ಸಿಂಪಲ್ ಪಾಯಿಂಟ್. ಇಟ್ ವಿಲ್ ಬಿ ಎ ಮ್ಯಾರಥಾನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫಾರ್ ಅದಕ್ಕೆ ಟೈಮ್ ಹೆಂಗೆ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಆ ಟೈಪ್.
ನೀವ್ ಹೇಳೋದು ಕರೆಕ್ಟು ಅಂತ ಹೇಳಿ ಅನ್ಸ್ಬೋದು ನಮ್ಗೆ. ಬಟ್ ಇನ್ ಎ ಸಿಚುವೇಶನ್ ಲೈಕ್ ಅವರ್ ಕಂಟ್ರಿ ವೇರ್ lawyers come from different background, their understanding is different, their communication methodology is different. ಅವ್ರಿಗೆ ಎಷ್ಟೋ ಸತಿ ಏನ್ ಹೇಳ್ಬೇಕು ಅಂತ ತಲೆಯಲ್ಲಿ ಇರತ್ತೆ, ಬಟ್ ಅದನ್ನ ಹೇಳಕ್ಕೆ 2 ನಿಮಿಷ ಬದಲು ಒಂದೊಂದ್ಸತಿ ಅರ್ಧ ಗಂಟೆ ಮಾಡ್ತಾರೆ ಅದು ಹೇಳಕ್ಕೆ. ಅದಕ್ಕೆ why I was also insisting, or why I was recommending, is a finishing school for all lawyers. We need to have a finishing school. ಕಾಲೇಜಲ್ಲಿ ಏನ್ ಹೇಳ್ಕೊಡ್ತಾರೆ, ಇವಾಗ ನಾವೇನ್ ಮಾತಾಡಿದೀವಿ ಅಂಡ್ ಕಾಲೇಜಲ್ಲಿ ಏನ್ ಹೇಳ್ಕೊಡ್ತಾರೋ is only the academical part of it, the theoretical part of it. Today colleges have moot courts, colleges have mediation clinics, legal service clinic. All the technical, the colleges should start teaching students about e-filing, about all these things that we spoke of at the college level only, so that they are, by the time they come out of college, they have this. But of course, that is only for people who want to litigate. ಇವಾಗ ಎಷ್ಟೋ ಜನ they are not decided whether they want to litigate or not. ಅದಕ್ಕೆ 3 ವರ್ಷ ಕೋರ್ಸ್ ಇರ್ಬೋದು, 5 ವರ್ಷ ಕೋರ್ಸ್ ಇರ್ಬೋದು. ಅದಾದ್ಮೇಲೆ we need to have a finishing school to teach them 3 months or 6 months. It is well worth it that people spend that 3 ತಿಂಗಳು 6 ತಿಂಗಳು to understand what is to be presented before the court and in what manner. Now the judge spoke about Kenyan courts. That was before the Kenyan Supreme Court. Now, when Kenyan Supreme Court you are speaking of, the standards are different if we have it in the Supreme Court of India also. Because most lawyers are like that. And there, the Kenyan Supreme Court is a constitutional court. It's not like our court where it's the appellate court also.
Yes.
So as a constitutional court where you are...
ಅದಕ್ಕೆ ನಮ್ಮಲ್ಲಿ ಅದಕ್ಕೆ ಈಗ ಈ ಜನರೇಷನ್, ಈಗ ನೆಕ್ಸ್ಟ್ ಜನರೇಷನ್ ಏನ್ ಬರುತ್ತಾ ಇದೆಯಲ್ಲ, ಸೊ ಅವ್ರಿಗೆ ಆತರ ಟ್ರೈನಿಂಗ್ ಕೊಟ್ಟು ಅದನ್ನ ಮುಂದೆ ಇದನ್ನ ಇಂಪ್ರೂವ್ ಮಾಡಬಹುದಲ್ಲ ಅಂತ. ಜನರೇಷನ್ ನಾವೆಲ್ಲ ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಜನರೇಷನ್ ಅದನ್ನ ಅವರಿಗೆ ಆತರ ಟ್ರೈನಿಂಗ್ ಕೊಟ್ರೆ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಇಂಪ್ರೂವ್ಡ್. ಜುಡಿಷಿಯರಿ ಇಂಪ್ರೂವ್ ಆಗುತ್ತೆ ಅಲ್ಲ, ಇದು ಬಹಳಷ್ಟು
over a period of time it will be done. But looking at our situation where we have appellate remedy and much of the litigants are not legally literate, and lawyers also coming from various backgrounds, time fixation may not be a great idea right now for those matters. And now ನೋಡ್ಬೇಕಾಗಿರೋದು ಡಿಸ್ಪೋಸಲ್ ಅಂತಲ್ಲ, ಜಸ್ಟಿಸ್ ಅಂತ ನೋಡ್ಬೇಕು. ಜಸ್ಟಿಸ್
ಕರೆಕ್ಟ್. ಅದೇ ಈಗ ಕೆಲವೊಂದು ಏನಾಗುತ್ತೆ, ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ನಲ್ಲಿ ಬರೀ ಜಸ್ಟ್ ಏನೋ ಪೊಸೆಷನ್ ಇದಾರೋ ಇಲ್ವೋ ಅಷ್ಟೇ ಇರುತ್ತೆ. ಬಟ್ ದೇ ವಿಲ್ ಟೇಕ್ ಎ ಮ್ಯಾರಥಾನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫಾರ್ ದಟ್.
ಅದು ಫಾರ್ ಲಾಯರ್ಸ್ ಆಲ್ಸೋ we have to
ಎಕ್ಸಾಂಪಲ್
sensitize them and we have to train them. We need to look at that way to see that justice is done. Justice not only done but seen to be done alla namdu. So time restriction itbiಟ್ಟು ಅವ್ರಿಗೆ ನಾವು ಏನ್ ಹೇಳ್ಬೇಕಾಗಿದೆ ಅಂತ ನಾವು ಹೇಳಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಒಂದೊಂದ್ಸತಿ ನೀವು ಹೇಳೋದು ಕರೆಕ್ಟ್, ಮ್ಯಾರಥಾನ್ ಆಗತ್ತೆ, ಇಟ್ ಇಸ್ ನಾಟ್ ನೆಸೆಸರಿ. But all opportunity would have to be given to the litigant to place his or her case before the court.
Yes, thank you.
Rudra Bhushan is asking transcript system. Transcript system, yes, people are working on it. If you recently saw in the Supreme Court used the Terrace software where the entire transcript of the day's proceedings was available in the evening itself. So we need to look at their transcription software which use artificial intelligence. Probably very shortly we will have live transcription which could happen, and when we're dictating it would be ready immediately. So that's a very very much required situation which should happen. How to improve practical knowledge during student life? Practical knowledge can only be improved by practice, not by
internship is the best thing. Internship is the best.
Internship. Now, if you're looking at litigation, you should do an internship with a district lawyer, with a high court lawyer, with a district judge, with a high court judge, if possible. If availability is there, you should look at all those things. How ChatGPT different from Google search engine? There's a lot of difference. This may not.
Sir, ಒಂದೇ ಒಂದು ಕ್ವಶನ್ ಸರ್. ಈ ಹೈಬ್ರಿಡ್ ಸಿಸ್ಟಮ್ ಇಂದ ಜೂನಿಯರ್ ಲಾಯರ್ಸ್ ಕಡಿಮೆ, ಈಗ ಸ್ಕಿಲ್ಡ್ ಲಾಯರ್ ಇದ್ರೆ ಜೂನಿಯರ್ ಲಾಯರ್ಸ್ ಗಳಿಗೆ ಏನಾದ್ರು ತೊಂದರೆ ಆಗ್ಬಹುದಾ? ಯಾಕಂದ್ರೆ ಈ ಸಿಸ್ಟಮ್ ಎಲ್ಲಾ ಸೀನಿಯರ್ ಮಾಡ್ಬಿಟ್ರೆ ಜೂನಿಯರ್ಸ್ ಏನಾದ್ರು ತೊಂದರೆ ಆಗ್ಬಹುದಾ ಅನ್ನೋದು.
ನಂಗೇನಿಲ್ಲ ಮಧುಸೂದನ್. ನನ್ ಮುಂದೆ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಲಾಟ್ ಆಫ್ ಜೂನಿಯರ್ಸ್ ಹೂ ಅಪಿಯರ್ ಥ್ರೂ ವಿಸಿ.
ಓಕೆ.
ನಂಗೆ ಬಹಳ ಜನ ಜೂನಿಯರ್ಸ್ ಆರ್ ಯೂಸಿಂಗ್ ದ ವಿಸಿ ಟು ಅಪಿಯರ್. ಗೋಯಿಂಗ್ ಫಾರ್ವರ್ಡ್ ಕೆಲವರಿಗೆ ಯಾರ ಹತ್ರ ಇದು ವಿಸಿಗೆ ಎಕ್ವಿಪ್ಮೆಂಟ್ ಇಲ್ವೋ ಅವ್ರು ಸ್ವಲ್ಪ ಫಿಸಿಕಲಿ ಬರ್ತಾ ಇದ್ದಾರೆ. ಬಟ್ ಈ ಸೇವಾ ಕೇಂದ್ರ, ಗ್ರಾಮವನ್ ಅಲ್ಲೆಲ್ಲ ಹೋದ್ರೆ ಅಲ್ಲಿಂದಾನು ಬರಬಹುದು. ಯು ಕ್ಯಾನ್ ಅಪಿಯರ್ ಥ್ರೂ ವಿಸಿ ಬೈ ಫೋನ್. ಕರೆಕ್ಟ್ ಆಗಿ ಕಾನ್ಫಿಗರ್ ಮಾಡಿದ್ರೆ ಯೂಸ್ ಮಾಡಬಹುದು. ಅದೇನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. I think the questions on the chat are done. Any other questions idea?
Sir, scrutiny, what is scrutiny, sir, after filing the e-filing?
The scrutiny will also become online.
Oh, yes,
you should be able to new scrutiny. Suppose you filed 15 annexures and only one annexure has some issue.
Yes.
Everything else could be locked up, and only that annexure will be made available for you to rectify. Only that document could be uploaded and scrutiny completed. You can probably sit at office and scrutinize it and complete the scrutiny. For example, Kerala, they have scrutiny happening from 8 a.m. to 8 p.m. Filing 24 hours. E-filing 24 hours, scrutiny from 8 a.m. to 8 p.m. and you can do scrutiny by chat with the concerned officer. So there are innovations which are coming up. Well, a new idea those ideas could be implemented. Scrutiny will also be online. Delhi alone, they have implemented online scrutiny and online rectification. Any other questions? Any question? We can wind up.
Yes, sir. ಇದುವರೆಗೂ ಶಾಂತ ಚಿತ್ತದಿಂದ ಕೇಳಿದ ವಕೀಲ ಬಾಂಧವರಿಗೂ ಮತ್ತು ತಮ್ಮ ಜ್ಞಾನಧಾರೆಯನ್ನ ಹರಿಸಿದಂತ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ತಿಪಟೂರಿನಲ್ಲಿ ನಡೆದಂತಹ ಕಾರ್ಯಾಗಾರದ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಯೂಟ್ಯೂಬ್ ಲಿಂಕ್ ಅನ್ನ ಕಳಿಸಿದ್ದೀನಿ. ಅದರಲ್ಲೂ ಕೂಡ ಹೆಚ್ಚಿನ ಮಾಹಿತಿಯನ್ನ ನ್ಯಾಯಮೂರ್ತಿಗಳು ನೀಡಿದ್ದಾರೆ. ಮತ್ತೊಮ್ಮೆ ಇದೇ ರೀತಿ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮತ್ತೊಮ್ಮೆ ಸೇರೋಣ. ಶುಭ ಸಂಜೆ.
Thank you.